Because yesterday it was bookmarked, so maybe that's how.
Yes, we've seen.
It's looking like an improved version of Mr. Dave.
I'm sorry for yesterday.
No.
It's easier. I'm sorry it was my mistake. Actually, we use liquid text, so we mark it on liquid text.
You mark it on liquid text. A little problem because I was trying to go through the whole process of again quitting, then
Wait, please, Manoj. Just to complete the.
so we've yes, you can now take us through any other statutory provisions that we have missed yesterday, so that
Yes.
then we are
There's
complete.
just one at page, section 39. The bookmark of the Motor Vehicles Act, Manoj, page 355.
SWOT.
Such is the necessity for registration.
Just give me 1 second.
Sorry.
There's some problem today. It's not coming. Yeah, I'm not getting the. Getting power. You know, I am.
Should I hand over a bookmark copy in an iPad for your lordship's convenience? That's 335. 30.
Yes.
335 is necessity for registration in the chapter for registration of motor vehicles. Just reading 39 for a purpose, Manoj. No person shall drive any motor vehicle, and no owner of a motor vehicle shall cause or permit the vehicle to be driven in any public place or in any other place unless the vehicle is registered in accordance with this chapter. The certificate of registration of vehicle has not been suspended or cancelled, and the vehicle carries a registration mark displayed in the prescribed manner, provided that nothing shall apply if the motor vehicle is in possession of a dealer subject to such conditions. Now, 41, Manoj, registration, how to be made. An application by or on behalf of the owner of a motor vehicle for registration shall be in such form and shall be accompanied by such document, particulars and informations, and shall be made within the such period as may be prescribed by the central government, provided that where a motor vehicle is jointly owned, Manoj, Lordship may skip that. Come to 4, Manoj, if your Lordships don't mind, please. Is that in addition to, which is at page 336, in addition to the other particulars required to be included in the certificate of registration, it shall also specify the type of motor vehicle, being a type as the central government may, having regard to the design, construction, and use of the motor vehicle by notification in the official gazette specify. So here for the registration purposes, one has to mention the design, the construction and use of motor vehicles by notification. This is where, my lords, according to me, in my respectful submission to your lordships, weight comes in It will mention, my lords, the number of cylinders, the cc that is there, the cubic capacity of the engine, and for what purpose is it being used.
Yes.
Because after all, my lords, your lordships may also have to give effect to what is the purpose of mentioning weight in the definition section. Some purpose is attached to that weight. That one is classified as 7,500, other is medium between 12,000 and 7,500. So a purpose is there. And that purpose is there in the Motor Vehicles Act, my lords, as far as the registration is concerned. It's there, my lords, under the Income Tax Act, where I checked up, because sometimes where it's like a house property, where if you are owning a commercial vehicle, transport vehicle of a particular weight, then you are required to pay a particular tax on it, which is dependent on the weight. That is, my lord, section 44AE of the Income Tax Act. So that has a deemed income concept in it. If you are owning a transport vehicle of a particular weight that is given, heavy goods vehicle or other than heavy goods vehicle, there is an income tax that attaches to it. So weight has a particular significance for the description. It could be for any other purpose, and the 44AE says that the definition of vehicles shall be unladen weight, etc., shall be as per the Motor Vehicles Act. So that, in my respectful submission, would be the why weight is mentioned in this. Now, if the weight is there, my lords, the ordinary cars, my lords, even the cars that your lordships have, are about between 1,800 to 2,000 kilograms. They rarely go up to 6,000 or 7,000 kilograms as far as motor car is concerned, my lords, because that even an SUV, I checked up, my lords, is higher side is 3,000, 3,500 kilograms. So it may be an LMV, but the certificate of registration would mention LMV, cylinders, weight, unladen weight is of this particular purpose. Unladen weight also has some significance, my lords. One can't tinker with that unladen weight once the vehicle has come to the person, that you add some iron thing, a grill which takes the weight to far exceeds the unladen weight of 7,000, though it's classified as LMV, but you've added certain things to it which takes the unladen weight away. So by weight necessarily may not be a good criteria to go by, because it is defined as 7,500 and it's a transport vehicle or an omnibus. They'll all fall in one category of this, my lord. Now, yesterday, the question that fell from the bench, my lords, was about the rules. Your lordships wanted to see the rules, my lords.
We are at page 436, your
Lordship pleases, my lords. As far as the licensing regime is concerned, your lordships were desirous of seeing the 436. It starts, my lords, after they are quite detailed, the rules. And chapter 2, my lords, at 440 deals with licensing of drivers of motor vehicle. So 3 says, my lords, that the provisions of subsection 1 at 440, my lords, your lordships have that. Provisions of subsection 1 of section 3, which is the section which is falling for your lordship's consideration, shall not apply to a person while receiving instructions or gaining experience in driving with the object of presenting himself for a test of competence to drive, so long as such person is the holder of an effective learner's license issued to him in Form 3 to drive the vehicle. Such person is accompanied by an instructor holding an effective driving license to drive the vehicle, and such instructor is sitting in such a position to control or stop the vehicle. And there is painted in the front and rear of the vehicle this L, which is there. Then is evidence as to correctness as to age. Then 5 comes as far as the medical certificate is concerned, my lords. Since there is a divergence in the medical certificate for transport and other vehicles, every application for the issue of a learner's license or a driving license for making addition of another class or description of a motor vehicle to a driving license, or for renewal of a driving license to drive a vehicle other than a transport vehicle, shall include a self-declaration as to the physical fitness as appended in Form 2 and every such application for a license to drive a transport vehicle shall be accompanied by a medical certificate in Form 1A issued electronically on the portal by a registered medical practitioner referred to in subsection 3 of section 8. So the rule contemplates, my lord, that even if I have to switch from the class, if I have to go for transport vehicle, then I require a medical certificate from a medical practitioner. Because that's what, for making addition of another class. So the moment I, sorry,
Deepankar's job.
and therefore the proviso, my lords, provided that every application for renewal of a driving license to drive a vehicle other than a transport vehicle shall be accompanied by a medical certificate in Form 1A issued electronically on the portal of registered practitioner referred to in section 3 in the case of an application attained the age of 40 years. So that distinction between transport and other vehicle is maintained, my lords. Then your lordships may come to 10. Lordships may see 9 also, since Ms. Pathak requests me to read 9, my lords. 9 is, my lords, minimum training and language comprehension, requirement for driving of goods carriage, carrying dangerous and hazardous good. 1 year from the date of commencement of the Central Motor Vehicles Amendment 93, any person driving a goods carriage carrying goods of dangerous or hazardous nature to human life shall, in addition to being the holder of a driving license to drive a transport vehicle, also has the ability to read and write at least one Indian language out of those specified in 8th schedule of the Constitution and English, and shall also possess a certificate of having successfully passed a course consisted of following syllabus and periodicity connected with the transport of such goods. So then, my lords, it says syllabus is defensive driving, questionnaire, cause of actions, etc. My lords, then it goes. And therefore, then 10 comes as far as an application for learner's license is concerned. Application for learner's license. An application for the grant of a learner's license shall be made in Form 2 and shall be accompanied by the following documents and fee submitted electronically on a portal either accessed by the applicant himself with the help of a facilitation center, a medical certificate in Form 1A in case of an application for learner's license to drive a transport vehicle. I'm only pointing out the relevant part where transport is mentioned, my lords.
Actually, D is very important. In the case of an application for transport vehicle,
yes, my lords,
excluding whatever, the driving license held by the applicant. So in order to hold a license for a transport vehicle, you have to have an existing driving license.
I should have held it for 1 year according to the section.
Section says
your lordships.
1 year prior holding.
Right. Section 7. Section 7. Lords, 14, page 443. Says an application for a driving license shall be made in Form 4 and shall be accompanied by an application for driving license shall be made in Form 4 shall be accompanied by an effective learner's license specified the subsequent test as the case may be of competence to drive for each class and for issue of license. Each class specifically mentioned, my lords. The applicant's recent size photograph, and D, save as otherwise provided in Rule 6, A medical certificate in Form 1A in case of an application for license to drive a transport vehicle, and E in the case of an application for driving license to drive a transport vehicle, a driving certificate in Form 5 issued by the school or establishment from where the applicant received instructions. Lordships yesterday saw the distinction about holding 1 year's license and undergoing that training period for 1 year from a school before a transport vehicle license can be taken. Now, my lords, at page 444, Rule 17 is addition to driving license.
Addition to driving license.
So an application for addition of another class or description of motor vehicle to the driving license shall be made in Form 2 to the licensing authority and shall be accompanied by 1. That is an effective learner's license and driving license held by the applicant. B. The driving certificate in Form 5 in the case of an application for addition of a transport vehicle excluding e-rickshaw or e-cart. And the same requirement of medical certificate is specified in sub-rule E, my lords. Save as otherwise provided in Rule 6, a medical certificate in Form 1A in case of an application for addition to license to drive a transport vehicle. Then it's Rule 18, my lords, at page 445, which is renewal of driving license. Application for the renewal of a driving license shall be made in Form 2. I'll take your lordships to the form because Form 2 finds mention everywhere. To any licensing authority in the state in which the applicant ordinarily resides or carries on business and shall be accompanied by appropriate fee, etc. My lords. D. In the case of an application for renewal of license to drive a transport vehicle, again, the medical certificate in Form 1A or in the case of an application of renewal of license to drive a non-transport vehicle if the applicant has attained the age of 40. Then a certificate in Form 5 if renewal is to drive heavy goods vehicle and heavy passenger motor vehicle. 2. Where the driving license authorizes the holder of such license to drive a transport vehicle as well as any other vehicle, then the licensing authority shall, subject to the production of medical certificate, renew such license for the appropriate period as specified in subsection 2 of section 14, which generally for transport is 5 years, and for other classes it varies according to as the applicant's age increases gradually. Like this, it goes on below the rules, but the general theme that seems to run through it, that transport vehicles are treated in a different class altogether, which is the scheme which is flowing from the sections that your lordships had been pleased to read yesterday.
Yes.
My lords, I wanted to show to get a license, since we are on the rules, if your lordships are pleased to turn to page 449, Rule 31. They have a syllabus for imparting instructions in driving of motor vehicles.
Yeah.
And the syllabus is also different. It says the syllabus for imparting instructions in driving of motor vehicles of the schools or establishment shall be as follows. See table below. The lessons for training drivers of non-transport vehicles shall cover parts A, B, C, F, G, and K of the syllabus referred to in sub-rule 1, and the training period shall not be less than 21 days, provided that in case of motorcycles, sufficient compliance laws, motorcycle separate. 3. Lessons for training drivers of transport vehicles shall cover parts E, F, G, H, I, J, and K of the syllabus referred to in Subrule 1, and the training period shall not be less than 30 days. Then 4, my lords, the actual driving hours for trainees on driving non-transport vehicles shall not be less than 10 hours, and actual driving hours for trainees in driving transport vehicles shall not be less than 15 hours. And it sets out the various table that sets out what they have to read, and they are also sort of in a way divided between what is common and not uncommon between, if we see the chart, my lords. I'm not taking your lordships through that part. May just turn to Rule 62, which doesn't relate to license, it relates to validity of certificate of fitness. Because the argument in Mukund Devangan was that it is of a particular class, which is motor vehicle, but if it is of a particular class, light motor vehicle, then the validity of certificate in respect of a transport vehicle and other vehicles is clearly brought out, my lords, in 62. It's validity of certificate of fitness. A certificate of fitness in respect of a transport vehicle granted under section 56 shall be in form 38 and sorry, my lords, 52, my lords, at page 477. Sorry, my lords.
No problem. Certificate of fitness.
It's certificate of fitness. It says new transport vehicle, 2 years. Renewal of certificate of fitness in respect of transport vehicles, 2 years, up to 8 years, and 1 year for vehicles older than 8 years, for heavy good vehicles, heavy passenger motor vehicles onwards, and for medium goods vehicle, medium passenger motor vehicles, and light motor vehicles with effect from so and so. So renewal of certificate of fitness in respect of transport vehicle and transport vehicle, new transport vehicle, shall be 2 years.
Anything else in the rules now?
Just the form, if your lordships are desirous of seeing.
Yes, let's see the form.
If your lordships are pleased to turn to 685. That's Form 1A at 684. Just the heading falls in, the last part falls in 684. Is the medical certificate form, my lords? Because we've covered quite a bit of the medical part, my lords. Form 2 is the important form, my lords, which is at 685. And it is to be read with Rule 10, 14, 17, and 18, which I read to your lordships just now, my lords. Form of application of learner's license or driving license in addition of a new class of vehicle or renewal of driving license or change of address or name. And the form your lordships will find at 686. And at serial 1, my lords, it mentions class of vehicle applicable for new learner's license or new driving license, and it mentions motorcycle without gear, motorcycle with gear. It says light motor vehicle, my lords, and then there's the asterisk. The asterisk is, my lords, earlier, it would read transport vehicle would mention, my lords, earlier, transport vehicle, but this has been amended. And transport vehicle, it used to read, my lords, light motor vehicle as transport vehicle. So now the legislature has deleted transport vehicle part and has just light motor vehicle, adapted vehicle, medium or heavy goods or passenger vehicle as transport vehicle. And then explanation, my lords, non-transport vehicles include motorcycle with or without sidecar for personal use, mopeds, three-wheel for personal use, motor car for personal use. Transport vehicle includes a public service vehicle, a goods carriage vehicle, an educational institution, bus or private service. Light motor vehicle includes, and it has been substituted, the transport has been done away with in this part. Would read, my lords, transport vehicle, which is there in the definition, that in the form has been done away with now. This amendment, my lords, is in 2021 though. So the legislature itself has clarified that light motor vehicle includes omnibus, the gross vehicle weight of either of which, or a motor car or a tractor or road roller, the unladen weight of any of which does not exceed 7,500 kilograms. Then medium goods and heavy goods vehicle are there. Interesting, if your lordship sees others also, which is not covered in any of the above categories, includes harvester, excavator, forklift, trailer, crane mounted vehicles, agricultural tractor, power lift, tow trucks, breakdown and van recovery vehicles, construction equipment vehicles. A 5 at 687 says, my lords. In case of request for addition of a class of vehicle in transport category, please fill the following: enrollment number in the driving school, enrollment date, etc. That they want to drive a transport vehicle. Because for transport vehicle, as your lordships remember, the sections itself says that you should hold a license for an LMB for 1 year. So you've applied for LMB, and therefore the addition now comes that you want to apply for a transport vehicle. So on my own, I can't go on my 20th birthday and apply that I wish to drive a transport vehicle. That is not the scheme of the Act, Milords. It presupposes you have at least for 1 year driven a light motor vehicle, and then you will have an addition of a transport vehicle. This Form 2 has been dealt with at considerable detail, my lords, in Mukund Devangan. And my lords, this Form 5, etc., which really I don't think I should take your lordship's time.
Mr. Dave, there's one aspect which we have probably not cited.
Yes,
you
my lord.
see the syllabus,
Yes, my lord.
which is the syllabus for imparting instructions in driving of motor vehicles.
Yes, my lord.
Now 31J,
Yes, my
the
lord.
training for light motor vehicle driving is one. This is the syllabus.
Yes, my lord.
Then there is a separate syllabus for medium and heavy. And thereafter, there's another syllabus for two-wheeler driving.
Yes, my lords.
Now, these training institutes have to be provided a certificate.
Yes.
This certificate is to be issued in Form 5B.
Yes, my lords.
Now, this is to be as per 31II.
Yes,
31EII.
Yes, my lords.
Now, if the training is identical, the certificate issued is identical, and this is the certificate on the basis of which the license is to be applied for.
Yeah.
And what would be the import of these provisions?
Lordship pleases. My lords, in the table that your lordships are seeing, the table, The first one, since it says what is to be done by a non-transport vehicle in 31.2, covers part A, B, C, F, G, and K. 31.2, if your lordships sees, my lords. The lessons for training drivers of non-transport vehicles shall cover parts A, B, C, F, G, and K of the syllabus to sub-rule 1. And the training period shall not be less than 21. The lessons for training of drivers vehicles, transport vehicles covers E, F, G, H, I. So when applying for a transport vehicle, I have already undertaken A, B, C, F, G, and K in my examination. Thereafter, my lords, when I'm taking for transport, then I will cover parts E, F, G, H, I, J.
So there is an additional training.
There is an additional training, that is, which is 1 year after, and for a specified period of, it says 30 days, 21 days then for transport, I have to undertake a 30 days further training.
It covers E, F, G, H, I, J, and K.
K is important, my lords, because K, I think, deals with first aid, if I'm not mistaken. E, F, G, H. I is fire hazards, vehicle maintenance. K is first aid. So K being suitable for human life, my lords, if some accident takes place or one injures oneself while driving. So K becomes first aid. So the statute requires, or the rules require, that you undergo that training again as far as first aid is concerned. K is common, my lords, and public relations for drivers, G, is common. So like F, which is transport, traffic education. Medium and heavy vehicles, that is E, theory 2, transport. And that's why in C, your lordships will find, it will say light vehicles driving practice, which applies for LMB.
So, Mr. Dave,
Sorry.
perhaps we can say this.
Yes.
All those who are holding an LMV license,
Yes.
if they look at a truck driver,
Yes.
they must understand that he's better educated, at least from the license perspective.
Yes. Most certainly. At least.
Isn't it?
Yes. That assumption is there. If
Language, first aid, so many things he has to learn.
on a principle,
I don't think you are learning all that with your LMV license.
I don't think that way. On a ceteris paribus principle, Milos, everything else remaining the same. A bus driver or a truck driver in this is certainly more educated than me when I'm driving a.
But this language is interesting. We always thought truck drivers need to learn certain kinds of language, but that is not what it is talking about.
That language is excluded.
Yeah.
Transport language. Transport language.
That is excluded.
It's tough language. Difficult language.
In fact, they are better in.
Because if you lordships just sees the drive, though all of us ordinarily hold a driving license, at 881, which is Form 7, which is the form of driving license, they even provide to that much detail, laminated card without chip or smart card, visual inspection. It has, Milos, at 882, motorcycle with gear. It has class of vehicle, motorcycle with gear, LMB, which is shown in a car, transport as a category, and then motor vehicle of specified description. Non-transport, specified description. And I'm informed, vehicle category It will say NT is non-transport, TR is transport. So LNB, NT, TR, transport, and NTTR, there's a specific endorsement that has to be made there in the licensing category where what vehicle is being driven. Page 882. So transport, even if it's LMV, it will say non-transport or it will say LMV transport.
Where is it in 882?
Lordships has that where motorcycle and all are made on the left side, my lords.
Yeah, this one.
Yes, car.
Car hai, choti si.
It's the last bookmark, my lords, forms.
Column 11.
Gives out those pictures, that kind of picture of a driving license. So my learned friend's original compilation, the SEC didn't have it. So therefore he's added it later so that something is not missing. This is important.
Personal symbol mentioned.
Now there's the oblique.
Yes,
Is it and or is it alternative?
it's alternative.
Oh, NT is it? Oh, I see. Does any of the juniors have a license here? I didn't want to ask the seniors to do that.
Your junior is.
Anyway, his is valid only for
My learned brother has one. Surely.
I'm saying his junior is here.
To date,
You are entitled to drive both.
non-transport. Military transport is different. Yeah. Oh, it says validity non-transport. You're right. Non-validity.
was mentioned.
Yeah.
License without this, two distinction.
Yes, but it may be.
Perhaps the licensing authority read the SCC version instead of.
No, that has come by way of an amendment.
That's right.
Before that, there used to be an endorsement. I'll show the old form also.
Exactly. Yeah. Gadi ka hai,
LME.
and then non-transport. This actually puts it beyond the pale of doubt, actually.
That's why I'm saying. I can take your lordships to Mukund Devangan.
In fact, it's exactly like the same
Same form.
form. Form is actually printed on the card. Same form. See inside.
I can imagine.
Let's see that.
It has to be.
Has to be, yeah. Now,
Same act
that's a
applies.
good thing, it's nationally unified now.
Yes.
This form has come in 2019. The earlier form had a separate plot thing saying
just
that endorsement for driving a transport vehicle.
This as being the same person as the holder of the license. It doesn't have your beard anymore. Oh.
I thought, why did Mr. Sood need to go to Tamil Nadu to get a license? But this is below the belt. That's it. Aadhaar, driving license, passport pictures are not to be shared.
And passport pictures are particularly bad because, the person who takes the photograph is constantly making you focus on that both your ears must be visible. Then, you must look in a particular way so that the reflection doesn't come in your specs. Or no glasses. In the olden days, at least, that was a...
Wear glasses, it's so difficult because if I take it off, I can't view even the court master clearly. Because that old form which Mr. Bhushan would place, it's there at page 880.
880?
880.
When did this new form come in?
2019, Mr. Bhushan. But the form itself starts at 878. And at 878, your lordships will find right at the bottom of 878, transport vehicle, light motor vehicle, road roller, etc. mentioned. And a motor vehicle of a specified description, namely the license to drive a motor vehicle other than transport vehicle at page 879 is valid from so and so to so and so. License to drive transport vehicle or e-rickshaw, e-cart is valid from this date to this date.
So even before the amendment, it was very clear that the license was to drive a motor vehicle other than a transport vehicle.
No, and just below that, your lordship will find
Name.
authorization to drive transport vehicle. Therefore, the first two, LMV may be different from transport vehicle, but the second, the authorization to drive a transport vehicle may come on an LMV license.
Right.
Because earlier, my lord, that section 10 did not have transport vehicle separately till the 2000 and,
So, 94.
94 amendment. 94 amendment. Section 10 was changed in 1994 and transport vehicle came there then. But even earlier, section 3 said that you will not be permitted to drive a transport vehicle unless your license specifically authorizes you to do so. So at that stage, they used to make an endorsement on a light motor vehicle or a medium motor vehicle or a heavy motor vehicle saying that you are authorized to drive a transport vehicle.
Yes.
So I would assume, Milord, that all persons who hold a transport vehicle license can drive a light motor vehicles, but all those who hold a light motor vehicle license can't drive a transport vehicle unless there is a specific endorsement.
Yes.
That is the scheme of the Act.
Yes, Mr.
Yes.
Does your lordships like to see Devangan? Because I'm done with the scheme of the.
Briefly, yes, let's do that because it's,
Devangan and then we'll start.
It's the fourth bookmark, Milords, on your lordships' computers. Milords. Starts at page 56. After the head notes, Milord, it starts at 67.
Oh, yeah.
At page 67. In the reference, the main question involved is whether a driver who is having a license to drive light motor vehicle and is driving transport vehicle of that class is required additionally to obtain an endorsement to drive a transport vehicle. There is a conflict in the plethora of decisions of this court, and various decisions have been set out by your lordships, my lords, in the judgment. Then 3, my lords, paragraph 3. Following questions have been referred for decision to the larger bench. What is the meaning to be given to the definition of light motor vehicle as defined in section 221 of the Motor Vehicles Act, whether transport vehicles are excluded from it, and 2, whether transport vehicle and omnibus, the gross vehicle weight of either which does not exceed 7,500 kgs would be a light motor vehicle, and also motor car or tractor or a road roller, unladen weight of which does not exceed 7,500 kgs, and holder of a license to drive the class of light motor vehicle as provided in 10(2)(d) would be competent to drive a transport vehicle or omnibus, the gross vehicle weight of which does not exceed 7,500 kgs, or a motor car or tractor or road roller, the unladen weight of which does not exceed 7,500 kgs. The second question is more or less the definition of what is contained in 221. Then 3, my lords, what is the effect of the amendment made by virtue of Act 54 of 94, with effect from 14/11/94, while substituting clauses E to H of section 10(2) which contain medium goods vehicle, medium passengers motor vehicle, heavy goods vehicle, and heavy passenger motor vehicle by transport vehicle, whether insertion of expression transport vehicle under section 10(2)(e) is related to said substituted classes only, or it also excluded transport vehicle of light motor vehicle class from the purview of section 10(2)(d) and section 241 of the Act. What is the effect of amendment of Form 4 as to the operation of the provisions contained in section 10 as amended in the year 1994, and whether the procedure to obtain the driving license for transport vehicles of the class of light motor vehicle has been changed. There is conflict in the aforesaid decisions of this court with respect to the legal position as to pre-amended and also post-amendment legal position of the amendment made on 28/3/2001 in the forms of driving license. In order to answer the questions, it is necessary to consider the various provisions of the Motor Vehicles Act. Those provisions your lordships have already seen, my lords, but may only notice that there is in para 5, my lords, a reference to section 3. It is referred to, and what your lordships are pleased to hold, my lords, are below the quoted part, that it is apparent from the provisions contained in section 3 that it is necessary to have a license to drive motor vehicle in any public place, and in order to drive a transport vehicle, the driving license must specifically entitled him to do so. The question is, what is the meaning to be given to transport vehicle under section 3? Then is the driving license section 10 is set out, my lords, and the comment is para 7, that section 10 deals in the forms and contents of the license to drive. Section 10, as it stood before its amendment made in the year 94 by virtue of Amendment Act 54 of 94, is extracted here under. This your lordships may kindly see. Every learner's license and driving license, except for driving, all that is same, my lords. Para 2 is the only, subclause 2 is the only part, my lords, where it went up till J, which is motorcycle without gear, motorcycle with gear, invalid carriage, light motor vehicle, medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle, heavy passengers, road roller, and motor vehicle of specified description. So it went up with all these categories of J till J. And then, my lords, para 8, it is apparent from the pre-amended provision which existed before the amendment made in the year 94 that class or description of the vehicle for which license used to be issued were categorized inter alia as light motor vehicle, medium goods vehicle, medium passengers motor vehicle, heavy goods vehicle, heavy passengers motor vehicle, and motor vehicle of a specified description. Transport vehicle was not a separate class, and it could be categorized under sections 10(1)(d) to H. So anywhere from light motor vehicles to medium goods vehicle to motor vehicles of a specified or till heavy passenger motor vehicle. Sorry, the amendment has been made in section 10 by virtue of the Amendment Act. The statements and objects of the reason of the Amendment Act being relevant is extracted hereunder. Statements of objects and reason. The Motor Vehicles Act 1988 consolidated and rationalized various laws regulating road transport. The Act came into force with effect from 1/7/89, replacing the Motor Vehicles Act 1939. After the coming into force of the Motor Vehicles Act 1988, government received a number of representation and suggestions from the state government, transport operators, and members of public regarding the inconvenience faced by them because of the operation of some of the provisions of the 1980 Act. A review committee was therefore constituted by the government in March 1990 to examine and review the 1980 Act. 3. The recommendations of the review committee were forwarded to the state government for comments, and they generally agree with these recommendations. The government also considered a large number of representations received after finalization of the report of the review committee from the transport operators and public for making amendments in the Act. The draft of the proposal based on the recommendation of the review committee. Representations from the public were placed before the Transport Development Council, seeking their views in the matter. The important suggestions made by the Transport Development Council relate to on or off or on account of A, the introduction of newer types of vehicle and fast increasing number, both commercial and personal vehicles in the country, providing adequate compensation to victims of road accidents without going into long-drawn procedure, protecting consumer interests in transport sector, concern for road safety standards, transport of hazardous chemical and pollution control, delegation of greater powers to state transport authorities, rationalizing the role of public authorities in certain matters. F, the simplification, since it's italized, I'll read that, the simplification of procedures and policy liberalization in the field of road transport and enhancing penalties for traffic offenders. Therefore, the proposed legislation has been prepared in the light of above background. The bill inter alia provided for modification and application of certain definitions of new type of vehicle, simplification of procedure for grant of driving licenses, putting strict restrictions on the alteration of vehicle, certain exemptions for vehicles running on non-polluting fuels, sealing on individuals or companies' holdings removed to curb Benami holding, states authorized to appoint one or more state appellate tribunals, punitive checks on the use of components that do not conform to the prescribed standards by manufacturers, and also stocking sale by traders, increase in the amount of compensation of the victim's hit and run, removal of time limit for filing of application by road accident victims compensation, punishment in case of certain offences is made stringent. K, a new predetermined formula for payment of compensation to road accident victims on the basis of age income, which is more liberal and rational. The Law Commission in its 119th report had recommended that every application for a claim be made to the claims tribunal having jurisdiction over the area in which the accident occurred, or to the claims tribunal within which the local limits of whose jurisdiction the claimant resides or carries on business, or within the local limits of those for whose jurisdiction the defendant resides at the option of the claimant. Bill also makes necessary provisions to give effect to the said recommendation. Pre-amended provision of Section 10 contained the vehicles of 10 kinds in Sections 10(2)(a) to J. In order to simplify the procedure for obtaining the license category, like medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle, and heavy passenger motor vehicle were deleted, and one category was inserted for these four kinds of vehicle in the form of transport vehicle in Section 10(2)(e), so that drivers are not required to obtain the license again and again for the aforesaid four kinds of vehicle. The provision of Section 10 after the amendment made by 54 of 94 is extracted here under forms and contents of license to drive. Your lordships have seen this. So F to H are deleted, and road roller and J motor vehicles of specified description are retained, and E is the transport vehicle category that is added. 11. Before dilating further, it is necessary to consider other definitions. Your lordships have spent considerable time on the definition, so I'm skipping that with your lordship's permission, my lords, and coming to paragraph 16. Prior to the amendment in 1994, license for transport vehicle was clearly covered as per Section 10(2) in 5 categories, that is Section 10(2)(d) in light motor vehicle, Section 10(2)(e) medium goods vehicle, Section 10(2)(f) medium passenger motor vehicle, 10(2)(g) heavy goods vehicle, and 10(2)(h) heavy passenger motor vehicle. The license for light motor vehicle has been provided for in Section 10(2)(d). The expression transport vehicle has been inserted by virtue of Amendment Act of 1994 in Section 10(2)(e) after deleting 4 categories or classes of vehicles, that is medium goods vehicle, medium passengers motor vehicle, heavy goods vehicle, and heavy passengers motor vehicle. Earlier Section 10 did not contain separate class of transport vehicle. 17 is important because the definition of light motor vehicle makes it clear that for a transport vehicle or omnibus, the gross vehicle weight, either of which are a motorcycle, motor car, or tractor road roller, the unladen weight of any of which does not exceed 7,000 kgs. Gross vehicle weight has been defined in 215. The motor car or tractor or road roller, the unladen weight of any of which does not exceed 7,000, as defined in Section 248 of the Act, are also light motor vehicles. No change has been made by the Amendment Act of 54 of 1994 in the provisions contained in Sections 221 and 10(2)(d) relating to the light motor vehicle. The definition of light motor vehicle has to be given full effect, and it has to be read with Section 10(2)(d), which makes it abundantly clear that light motor vehicle is also a transport vehicle, the gross vehicle weight or unladen weight of which does not exceed 7,500 kgs as specified in the provision. Thus, a driver is issued a license as per the class of vehicles, that is light motor vehicle, transport vehicle, omnibus, or another vehicle of other categories as per gross vehicle weight or unladen weight as specified in section 221 of the Act. The provisions of section 3 of the Act requires that a person, in order to drive a transport vehicle, must have authorization. Once a license is issued to drive light motor vehicle, it would also mean specific authorization to drive a transport vehicle or omnibus, the gross vehicle weight, or a motor car, road roller, or tractor, the unladen weight of which, as the case may be, does not exceed 7,500 kg. The insertion of transport vehicle category in section 10(2)(e) has no effect of obliterating the already defined category of transport vehicle of the class of motor vehicle. A distinction is made in the Act of heavy goods vehicle, heavy passenger motor vehicle, medium goods vehicle, and medium passenger motor vehicle on the basis of gross vehicle weight or unladen weight for heavy passenger motor vehicle, heavy goods vehicle, the weight of which may be exceed, which as the case may be, exceeds 12,000 kgs. Medium goods vehicle shall mean any goods carriage other than a light motor vehicle or a heavy goods vehicle, whereas medium passenger motor vehicle means any public service vehicle, or private service vehicle or educational institution bus other than a motorcycle, invalid carriage, light motor vehicle, or heavy passenger. Thus, the newly incorporated expression transport vehicle into 10(2)(e) would include only the vehicles of the category as defined in section 216, heavy goods vehicle, 217, heavy passengers motor vehicle, sections 223, medium goods vehicle, and section 224, medium passengers transport vehicle, and would not include the light motor vehicle, which means transport vehicle also of the weight specified in section 221. Form 4 has led to some of the divergent views of this court, which was prevalent before 28/3/2001, prescribed under Rule 14 of the Central Motor Vehicles Rules, hereinafter referred to as the rules. The relevant portion is extracted here and below. Well, all these categories I had shown to your lordships and lords. At page 75, the form is set out. The aforesaid form, para 20, the aforesaid form was in vogue till 28/3/2001, in spite of the amendment made in the year 1994, deleting sections 10(e) to h. The form in which application was required to be made was not changed and came to be changed only in the year 2001 so as to carry out the effect of the amendment. The relevant extract of the amended form, as amended on 28/3/2001, by which the expression transport vehicle has been inserted, is extracted here and below, and this is the amendment. Your lordships were pleased to see this form earlier. Para 21. Though Form 4 has undergone other changes with respect to item A, motorcycle without gear, same is not relevant for our purpose. Form 4 makes it apparent that light motor vehicle is a description of the kind of vehicle as defined in section 221. A transport vehicle of a light motor vehicle category is not at all excluded in the form. Even otherwise, the form cannot control the substantive provisions carved out in section 10(2)(d) and 10(2)(e). The interpretation of the form is also to be in tune with the statements of objects and reasons and the provisions of the Act inserted by virtue of the amendment. Though it appears that in the amended form, medium passenger motor vehicle remains, that appears to be more due to oversight. Thus, as intended, the simplification of the procedures and policy liberalization has taken place by introducing in the form category of transport vehicle instead of medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle, and heavy passengers motor vehicle. The policy of liberalization became necessary with an introduction of newer types of vehicle and fast increasing number of both personal and commercial vehicles in the country. In case it was intended to take transport vehicle out of the category of the light motor vehicle, then it was necessary to amend section 221 and section 10(2)(d) also, which has not been done. Thus, the intendment of the amendment has to be taken by addition of transport vehicle of the aforesaid categories of medium and heavy vehicles only, so that a person is required to apply for license only once to drive aforesaid 4 kinds of vehicle as per the amended provision of section 10(2)(e) and the form. Our aforesaid conclusion is also fortified by the inclusion of Rule 8 of 1989 rule which provides for minimum educational qualification for driving transport vehicle to be 8th standard. The provisor to the rule makes it clear that the said qualification shall not apply in the case of renewal of driving license to drive a transport vehicle and or addition of another class of transport vehicle to the driving license already obtained before commencement of the Motor Vehicle Act 2007. Amended Rule 8 as inserted in 2007 is quoted below. Minimum educational qualification for driving transport vehicle. The minimum educational qualification in respect of an applicant for obtaining a license to drive a transport vehicle shall be a pass in the 8th standard, provided that the minimum educational qualification specified in this rule shall not apply in the case of a renewal of a driving license to drive a transport vehicle or addition of another class of transport vehicle to the driving license already held before the commencement of the motor vehicle. The backdrop history indicates that the earlier aforesaid rule existed. It was omitted in 89. It had been reinserted in 2009. Rule 8 contemplates that in addition to transport vehicle of another category and the existing one in license, in 2007, the existing category of transport vehicle could only be light motor vehicle in section 10(2)(d), and another category of transport vehicle to be added is only as the amended provision in section 10(2)(e). Rule 8 refers to the addition of transport vehicle to light motor vehicle category. Otherwise, no purpose would be left behind insertion of Rule 8 again in 2007 in case transport vehicles of all categories are read into section 10(2)(e). Rule 8 also unambiguously lends support to the legislative intentment behind section 10(2)(e). Any other interpretation would make it redundant. Rule and exercise in futility is not undertaken by legislation. I may request your lordships to pause here and please consider this Rule 8 which is mentioned, because we have not seen this part, my lords. This is when a rule is reintroduced. It says that for renewal of a driving license to drive a transport vehicle, you are not required to be passing of 8th standard. That means, my lords, it would not have been possible for those who are already held without this qualification to be there for 8th standard pass to then complete their education and then apply for renewal.
Let's read that again.
Yes, my lord. Please see. Minimum educational qualification for driving transport vehicle. It's introduced on 10/4/2007. Is quoted below. Minimum education. The minimum educational qualification in respect of an applicant for obtaining a license to drive a transport vehicle shall be a pass in the 8th standard, provided that the minimum educational qualification specified in this rule shall not apply in the case of renewal of a driving license to drive a transport vehicle or addition of another class of transport vehicle to the driving license. So since it's introduced in 2007 again, and I was already holding it without this requirement of being 8th class pass, so the legislature found it fit to say that if you are renewing it, you don't have to then go and complete 8th standard and then come back, because that would have been the requirement otherwise. So the legislature clarified that for this purpose, as far as renewal is concerned or adding a class, you don't have to go back to school and complete 8th standard and then come back, which you were doing till hitherto, because it came right in the middle of by way of amendment to those who are already holding. But if you were applying for a transport license in 2007, then the requirement was that you ought to have completed the till 8th standard education. And now, my lord, this is no longer valid again, because my junior rightly informs me that this is omitted again in 2019. So the interpretation that is given in this judgment, my lords, may not be correct in my respectful submission, because 8 does not help that this part, my lords, at 78, that about third line from below, my lords, Rule 8 also unambiguously lends support to the legislative intent behind section 10(2)(e). Any other interpretation would make it redundant rule. An exercise in futility is not undertaken. Great respect, the exercise undertaken by the legislature was a correct one. It protected those who already held a transport license, not to then go and get that other requirement, because it would have been very difficult for them. Driving license, para 24, my lords. Driving license is issued in Form 6 as provided in Rule 16 of 1989 rules. Form 6 is extracted here in below, my lords. This was also placed at page 79. A motor vehicles of the following description, etc. Driving license to drive a motor vehicle other than a transport vehicle. That's after the categories that is mentioned. This, your lordships has seen this with the space of endorsement. Then at para 25 is the opinion expressed by your lordships, my lords. Form 6 provides for light motor vehicle and transport vehicle separately. Though the form contains separate validity period for a motor vehicle other than transport vehicle, the aforesaid form and period of validity have to be understood in the light of the aforesaid discussion made by us of the light motor vehicle and transport vehicle. The form cannot govern the interpretation of the provision of sections 10(2)d and 10(2)e. Otherwise, also form has to be interpreted harmoniously with the Act and cannot be in conflict with the statutory provisions. The provision of the light motor vehicle has to be given full effect, and it is enjoined upon authorities to issue license in terms of the discussion made by us in the order, and validity period has to be construed accordingly. The validity period of transport vehicle of light motor vehicle license, which means the vehicle as defined under section in 221, has to be the same as that of other light motor vehicle of non-transport category, and there cannot be any distinction made with respect to the validity period of the class of light motor vehicle. The separate prescription for the validity of transport vehicle in Form 6 is only to take care of the provisions inserted in sections 10 to E. By deleting the provisions in sections 10 to E to H, it would apply to those categories. So this form also, my lords, again, it has been omitted in 2019 and been replaced, my lords, by what I showed to your lordships, my lords, where the photograph and the form with driving NR, NT and NR and NT and TR categories, my lords. So the forms part, because they keep changing, my lords, I'm skipping that part. Then at 82, my lords, right at the top, after going through another form, it is apparent that an application has to be made for addition of another class of vehicle. Light motor vehicle and transport vehicles are separately defined. Thus, it is clear that in the aforesaid form 4, 6 and 8, transport vehicle has to be understood in the category of vehicles for which provisions have been amended by sections 10 to E. The trade certificates dealt with section 34, I'm skipping the trade certificate part, Para 28, my lords, the aforesaid Rule 34 also makes a distinction between light motor vehicles, medium passenger motor vehicles, etc., heavy goods vehicle. For all types of vehicles, it is necessary that prototype of every motor vehicle qualify a test of the vehicle research and development establishment of the Ministry of Defence of the Government of India, Automotive Research Association of India as provided in Rule 126. The vehicle must conform to the provisions of the rules made under section 110. Relevant information has to be inserted as per 41. In the Act, and the registration particulars may be prescribed by the central government. Class of vehicles, gross vehicle weight, as well as unladen weight are required to be mentioned in the registration particulars in Form 20. The interpretation made by us is also supported by the syllabus which is prescribed for light motor vehicles and separately for medium and heavy vehicles. Driving practice. Rule 31 of the rules contains the syllabus for imparting instructions to the driving of motor vehicles in school and establishment. Syllabus is divided A to K. Your lordship saw this part, my lords. The question fell from your lordships, my lords, about this syllabus. It is on page 83, my lords. It is apparent from the aforesaid syllabus that no separate syllabus has been provided for transport vehicle. Transport vehicles have been included in the syllabus as per the class of vehicles. That is to say, syllabus of light motor vehicle would include the syllabus of transport vehicles of that class. The syllabus has been formulated as per the weight of the vehicle. I had shown to your lordships the syllabus. Your lordship saw that for transport vehicles there is a special requirement. Sorry, just Para 30, my lords, the state government has to maintain a register of motor vehicles under Rule 75 as provided in Form 41, which includes gross vehicle weight, unladen weight, etc. Central government has the power to frame rules under Section 27, inter alia, regarding minimum qualification forms and contents of the license. Thus, we are of the considered opinion that the definition of light motor vehicle under 10 to 21 of the Act includes transport vehicle of the class and weight defined therein. The transport vehicle of omnibus would be light motor vehicle, gross vehicle weight of which, and also a motor car or tractor or road roller, unladen weight of which does not exceed 7,500 kgs, and can be driven by holder of license to drive light motor vehicle, and no separate endorsement is required to drive such transport vehicle. It is settled proposition of law that while interpreting a legislative provision, the intention of the legislature, motive and philosophy of the relevant provision, goals to be achieved by enacting the same have to be taken into consideration. Then the judgment sets out various principles of statutory interpretation, which your lordships are well aware of. As far as this is concerned, may I skip these parts, as the interpretation and the
Para
judgments?
39.
Yes, Manoj. Para 39, then I'm obliged, Manoj. Para 39, Manoj, at page 86. From the aforesaid principles, it is apparent that plain and simple meaning has to be given to section 10(2). When the legislature has not amended the provision, we cannot rewrite the definition of section 221 of light motor vehicle and section 10(2)(d), and full effect has to be given to the omission which has been made in the provisions of section 10(2)(e) to h by substituting transport vehicle, and under 10(2)(e) and plain and literal interpretation of existing provision and amended provisions has to be made. When the legislature has not amended the aforesaid provision, it is not for the court to legislate by making insertions in section 10(2)(e). What has not been provided in the statute with a purpose cannot be supplied by the courts. The court has to construe provision and not act as legislature. In other words, interpretation suggested by the insurers would mean rewriting the provision, which is not permissible in the light of the aforesaid discussion. And your lordships may come to the various other judgments are there, my lords, and then 48. Then various other judgments, then the conflicting judgments, your lordships were pleased to set them out, my lords. And the final conclusion (53 or 50? 55, my lords, at page 100. Sections 10(2)(a) to j lay down the classes of vehicles to be driven, not a specific kind of motor vehicles in that class. If a vehicle falls into any of the categories, a license holder holding license to drive the class of vehicles can drive all vehicles of that particular class. No separate endorsement is to be obtained nor provided if the vehicles fall in any of the particular classes of section 2. This court has rightly observed in Nagashetty that in case submission to the contrary is accepted, then every time an owner of a private car who has license to drive a light motor vehicle attaches a roof carrier to his car or a trailer to his car and carries goods thereon, the light motor vehicle would become a transport vehicle and the owner would be deemed to have no license to drive that vehicle. It would lead to absurd results merely because a trailer is added either to a tractor or to a motor vehicle. It by itself does not mean the driver ceased to have valid driving license. In a considered opinion, even if such a vehicle is treated as transport vehicle of the light motor vehicle class, legal position would not change. The driver would still have a valid driving license to drive vehicle of a light motor vehicle class, whether it is transport vehicle or a private car tractor attached with trolley or used for carrying goods in the forms of transport vehicle. The ultimate conclusion in Nagashetty is correct, however, for the reasons as explained by us. And because there is for the tractor, etc. Para 58 at 102. Transport vehicle has been defined in section 247 of the Act to mean a public service vehicle, a goods carriage, an educational institution bus, or private service vehicle. Public service vehicle has been defined in 235 to mean any motor vehicle used or adapted to be used for the carriage of passengers for hire or reward and includes a maxi cab, motor cab, contract carriage, and stage carriage. Goods carriage, which is also a transport vehicle, is defined in section 214 to mean a motor vehicle constructed or adapted for use solely for the carriage of goods, or any motor vehicle not so constructed or adapted when used in the carriage of goods. It was rightly submitted that a person holding license to drive motor vehicle registered for private use who is driving a similar vehicle which is registered or insured for the purpose of carrying passengers for hire or reward, would not require an endorsement as to drive transport vehicle, as the same is not contemplated by the provisions of the Act. It was also rightly contended that there are several vehicles which can be used for private as well as for carrying passengers for hire or reward. When a driver is authorized to drive a vehicle, he can drive it irrespective of the fact whether it was used for private purpose or purpose of hire or reward or for carrying the goods in the said vehicle. It is what is intended by the provisions of the Act and Amendment Act of 54 of 94. Section 10 of the Act requires a driver to hold a license with respect to class of vehicles and not with respect to the type of vehicle. In one class of vehicle, there may be different kinds of vehicle. If they fall in the same class of vehicle, no separate endorsement is required to drive such vehicles, as light motor vehicle includes transport vehicle. Also, a holder of light motor vehicle license can drive all the vehicles of the class, including transport vehicle. It was pre-amended position as well as post-amended provision of position of Form 4 as amended on 28/3/2001. Any other interpretation would be repugnant to the definition of light motor vehicle in Section 221 and the provisions of Section 10(2)(d). Rule 8 and 1989 rules. Other provisions are, and also the forms which are in tune with the provisions. Even otherwise, the forms never intended to exclude transport vehicle from the category of light motor vehicles. And for the light motor vehicles, the validity period of such license hold good and apply for transport vehicle and such class also. And the expression in Section 10(2)(e) of the Act, transport vehicle would include medium goods vehicle, medium passenger motor vehicle, heavy good vehicle, heavy passenger motor vehicle, which earlier found place in Section 10(2)(e) and h, and our conclusion is fortified by the syllabus and the rules we have discussed. Thus, we answer the questions which are referred to. Light motor vehicles as defined in Section 221 of the Act would include a transport vehicle as per the weight prescribed in Section 221, read with Section 215 and 248. Such transport vehicle are not excluded from the definition of light motor vehicle by virtue of Amendment Act 954 of 94. A transport vehicle and omnibus, the gross vehicle weight of either of which does not exceed 7,500 kilograms, would be a light motor vehicle, and also motor car or tractor or road roller, unladen weight of which does not exceed 7,500 kilograms. Holder of driving license to drive class of light motor vehicle as provided in Section 10(2)(d) is competent to drive a transport vehicle or omnibus.
He has given the associated.
This is all subject to learned friends' arguments. And
Fair enough.
the
So,
only submission I would like to make is, my lords, if a new class is added as a transport vehicle, then all transport vehicles, wherever they are referred to, in the definition or otherwise in the, would then fall under for the purposes of the class which is included by a substitution. And then one can't go back and say, no, it is in LMV, so therefore don't include it here, which is the section which deals with for licensing purposes, read with section 3. And as your lordship saw, section 3 only referred to, but not dealt with otherwise. Why is there a separate, the second part of section 3 is specifically not dealt with, that and for a transport vehicle, you require that qualification. And deeply obliged.
Thank you, Mr. Dave. Thank you. Yes, Mr. Bhushan.
But your lordship has seen the
judgment is the most tedious part in the book.
issue really arises because of the definition of light motor vehicle, which includes a transport vehicle which is under 7,500 kilos. And therefore, that is the basis on which Lord Mukul Devangan has held that once you have a license for a light motor vehicle, that includes a transport vehicle of less than 7,500 kilos. Now, Lord Mukul Devangan has made a mistake in two crucial aspects. One is in dealing with section 3. Just have a look at section 3. And this section 3 was there, my lord, before the 1994 amendment, before transport vehicle was added in section 10(2). So even when there was no specific category of transport vehicle in the kinds of licenses you could get in section 10, section 3 was still there. And this is how it reads.
1 second. Let's get back to it for a second.
Yes.
What is the page?
319.
319.
This is the page. 319.
Yeah.
No person shall drive a motor vehicle in any public place unless he holds an effective driving license issued to him, authorizing him to drive the vehicle. Now pause here for a moment. If it was only till there, my lord, I could have understood that you could have said that light motor vehicle includes a transport vehicle. Therefore, if you have a transport vehicle of less than 7,500 kilos, a license authorizing you to drive a light motor vehicle authorizes you to drive a transport vehicle of less than 7,500 kilos. But it goes on further. And no person shall so drive a transport vehicle other than a motor cab or motorcycle. I'll come back to this motor cab, why this is excluded. Hired for his own use or rented under any other scheme made under subsection 2 of section 75, unless his driving license specifically entitles him so to do. Now, what is the meaning, my lord, of the second part? And no person shall so drive a transport vehicle. It clearly means that whatever your license, whether transport vehicle is included or not, but you cannot use that license to drive a transport vehicle unless your license specifically authorizes you to drive a transport vehicle. It's absolutely clear. I mean, it could not be more specific than this. What was the need of having the second part? If you were to say that no, light motor vehicle includes a transport vehicle of less than 7,500, and therefore, if you have a license to drive a light motor vehicle, you can drive a transport vehicle, even if your license doesn't specifically authorize you to do so. Then, my lord, the second part becomes otiose, it becomes totally redundant. Just excise it from that section for a moment and see the result is the same as what Mukul Devangan says it is. If Mukul Devangan is right, that merely because the definition of light motor vehicle includes a light transport vehicle, therefore, under section 3 it can be driven. what was the need to add, my lord, the second part? Those lines become totally redundant if my lord, the interpretation given by Mukul Devangan is accepted. And it's an accepted principle of law, my lord, that you cannot give any interpretation to any provision which makes certain words redundant.
Yes.
But may I immediately cite that judgment? It's a Constitution Bench judgment. Of course, there are several, but I'll cite only one. 2005, I've given a compilation of judgments in the morning.
That no part of a statute should be rendered redundant.
Correct.
So,
Correct.
that's very clear. Just give us a
Absolutely right.
citation,
So
that's
just
all, in the para.
Your Lordship may just note, my lord, 2005, 2 SAC, 271, paragraph 14.
What is the name?
It's called, my lord, Nathi Devi versus Radha Devi Gupta, and relies upon several other judgments which are mentioned in it, but I took out only one because it's Constitution Bench. I'll just read that one, paragraph 14. I'd given that compilation of judgments,
We've got it here.
if it can be shared.
Yes, they're sharing it.
Para 14.
Para 14.
Page 64 of the compilation. The running
Yes, we
page.
got it here.
Yes. It is equally well settled that in interpreting a statute, effort should be made to give effect to each and every word used by the legislature. The courts always presume that the legislature inserted every part thereof for a purpose, and the legislative intention is that every part of the statute should have effect. A construction which attributes redundancy to the legislature will not be accepted except for compelling reasons such as obvious drafting errors. See State of UP versus so and so, so and so, so and so. That's a well accepted principle. Now, Lord, what I'm submitting before your Lordship is, just see Mukul Devangan now. How it interprets, my lord, the section 3, how it deals with the section 3 is only in this one paragraph, that is paragraph 17. Page 74 of Mr. Dave's compilation. Your Lordship has placetum C, just one line below that. The provision of section 3 of the Act requires that the person, in order to drive a transport vehicle, must have authorization. Once a license is issued to drive light motor vehicle, it would also mean specific authorization to drive a transport vehicle or omnibus, the gross vehicle weight, or motor car, road roller, or tractor, the unladen weight of which, as the case may be, does not exceed 7,500 kilograms. This is how, my lord, this section 3, the second part, is dealt with. This, in my humble submission, is totally wrong. It is not a specific authorization to drive a transport vehicle. A license to drive a light motor vehicle is not a specific authorization. And this ignores this principle that in interpreting that, you cannot make any sentence of that otiose or redundant. If this is the correct interpretation, then, my lord, that second part, and no person shall so drive a transport vehicle, becomes absolutely redundant. If you remove it, this is the same interpretation, my lord, that will be given. Namely, if the light motor vehicle includes a transport vehicle, you will be authorized to drive it.
How do you
They really go by the definition of light motor vehicle.
Yes.
That first sentence of para 17, the definition of light motor vehicle
Yes.
makes it clear that for a transport vehicle or omnibus, the gross vehicle weight or either of which, or a motor car or tractor or road roller, the unladen weight of any of which does not exceed 7,500. That sentence is incomplete actually, but no change has been made by the amending act of 94 in sections 221 and 10(2)(d). The definition of light motor vehicle has to be given full effect to, and it has to be read with 10(2)(d), which makes it abundantly clear that light motor vehicle is also a transport vehicle. The gross vehicle weight or unladen weight of which does not exceed 7,500.
Therefore, my lord, this judgment goes purely by the definition. That only because the definition includes a transport vehicle, therefore, your license to drive a light motor vehicle includes a transport vehicle, but that totally,
How do you want the definition to be interpreted?
not the definition is for various
221.
other purposes
According
as
to you,
well.
how?
The definition, so therefore, the definition clause always says, unless the context otherwise requires. And therefore, my lord, it cannot be, this definition cannot be used for the purpose of section 3.1, particularly where the second part of section 3.1 says, and no person shall so drive a transport vehicle unless his driving license specifically entitles him to do so. What is the meaning to be given to the second part if, my lord, this judgment is correct? That you go only purely by the definition. Light motor vehicle includes transport vehicle. Therefore, a license to drive a light motor vehicle includes a license to drive a transport vehicle. Then what happens to the second part? What does specifically mean? Unless his driving license specifically entitles him so to do. And which is why your lordship sees the form specifically says authorization to drive a transport vehicle. Just see not that form that is quoted actually in this judgment. Your lordship has page 685 of the judgment. Sorry. Page 121. This one now, of course, it has become a lot. Your lordship has seen the license.
Word as defined.
If you have a license to drive a light motor vehicle, how is there a specific authorization to drive a transport vehicle? And that specific authorization was provided along the form.
The expression transport vehicle under 221 may not be used in the same manner as is defined in the section. It might have been a general usage, unless we see the original position as it were. 1959 Act, is it? Before this? 1959. 39.
See, one thing is very clear that
Yes.
a light motor vehicle includes a class which is wider than a transport vehicle,
Correct.
right?
Correct.
Because otherwise, light motor vehicle would be equated with a transport vehicle. Now, if you go back to section 221 at page 317 of Mr. Dave's compilation,
Means a transport vehicle
like light motor vehicle
Is that transport?
means a transport vehicle
or omnibus.
Omnibus is a vehicle which is so adapted to carry more than 6 passengers.
Correct.
The gross vehicle
Or a
weight,
motor car.
right? Or yes,
Or a motor car.
or omnibus, the gross vehicle weight of either of which, or a motor car, or tractor, or road roller. The unladen weight of which does not exceed 7,500
Correct.
kilograms.
So therefore,
So the expression transport vehicle in 221, is it to be read in the context of the definition of transport vehicle in 247?
47.
yes, I would say yes, except that it is qualified by that it should not exceed 7,500 kilograms. So all transport vehicles which are less than 7,500 kilograms would come under the definition of light motor vehicle under 221.
Where the gross vehicle weight is less than 7,500.
Yes. But that doesn't mean that if you have a license for driving a light motor vehicle, that gives you authorization to drive a transport vehicle less than 7,500 kilos. Why? Because section 3, which authorizes you to drive what kind of vehicle, namely whatever your license describes it as, has a proviso, or a sort of a proviso. But if you're going to drive a transport vehicle, then your license must specifically authorize you to do it.
Because the words, according to you, specifically entitles
Yes.
him so to do.
Yes.
These are words of some significance in the sense that Otherwise, everybody who holds a light motor vehicle license would be entitled to drive a transport vehicle.
Any of them, not only.
Now, supposing,
Unless
for
his driving
instance,
license specifically entitled. This also seems to indicate that the licensing regime is different from, just the definition
absolutely
regime.
right. And your lordship has seen, my lord, the form of license. There is a now, of course, my lord, under the amended rules, 2021 amendment, it says light motor vehicle transport or non-transport. So that makes it absolutely clear, but that has come only in 2021. The form earlier, when Mukund Devangan was there, also had, my lord, just have a look at Mukund Devangan itself. The form is given at page 685 of the judgment, which is not 121 of Mr. Dave's compilation. In para 24, that form is given. Sorry, 121 of our, just look at Mr. Dave's compilation. Yes, you're not.
And Justice Mishra's judgment holds that in section 10, the words transport vehicle were introduced on 14th November 1994.
Correct.
And all those other categories were also deleted. F,
Yes.
G, and H were deleted.
I'll come to that as to what is the effect.
He
of
says,
that
the learned
amendment.
judge says that the mere addition of the word transport vehicle in 1994
Yes.
does not obliterate the fact that yet a light motor vehicle is included.
So
a transport vehicle is included in the definition
I
of
am
the
for
light.
the moment, my lord, addressing your lordship
On
on
three.
what would have been the position prior to the amendment, even prior to the amendment, before transport vehicle was added as a separate, my lord, class under section 10. I am saying that even before 1994, my lord, because of section 3, which specifically said, had an exclusion that if you want to drive a transport vehicle, you can't go just by the categorization of the license. It must specifically authorize you to drive a transport vehicle.
And the principle in section 3, the principle in section 3, which is so very clear, is completely reflected in the entirety of the scheme of the
Absolutely
statute,
right, because there is a separate.
draws out very, very clear distinction
Absolutely right.
between transport and non-transport vehicles.
Supposing I get a LMB license
of
at
the
age
license
18.
are different. Medical certificate requirements are different.
Age is
Renewal, age.
The very fact that if I cannot get a license to drive a transport vehicle unless I've had a license to, I can't even get a learner's license to drive a transport vehicle unless I've had a license to drive an LMB for 1 year. Now, supposing, my lord, how is this judgment going to, my lord, reconcile all this? I get a LMB license at age 18, and according to that, my lord,
actually, if the construction which was placed by the court was right, then these words had no reason. The legislature had no reason to introduce these words in the second part.
Absolutely right.
Because then the first part would have been adequate. No person shall drive a motor vehicle in any public place unless he holds an effective driving license issued to him, authorizing him to drive the vehicle.
And that is why I cited that.
The second part was brought in specifically to cover only transport vehicles.
Right. So that renders that totally redundant.
That so shows otherwise, that second part.
It actually collapses the two separate features of the statute into one. So it's actually the section 3's bifurcation becomes redundant.
Absolutely.
And also half of the statute becomes redundant.
Correct. How do you, I can get a license at 18.
Okay.
I've seen.
Yes.
What
now,
else is?
My second point is post.
Just one.
So, my Lord, the position would be covered by section 3, and that is dehors the 1994
So that is your
amendment.
first reason
point.
why you say that it's
Right.
wrong. Now, what is the second reason why it is wrong?
Second reason, my Lord, is post 1994, when in section 10.2, E to H were deleted and E became transport vehicle. Now you have a separate category in the form of the license itself, namely transport vehicle. My submission is that the principle of generalia specialibus non derogant, or, my Lord, the equivalent principle generalibus specialia derogant, the first of which means, my Lord, that general things do not derogate from special things. The second of which is more important, is that special things derogate from general things.
What is the second Latin word?
It's generalibus specialia derogant. The principle is that if you have a specific or a special entry or a word, as against that you have a general, then whatever comes within the ambit of the special will be excluded from the general. Now, my Lord, in this case, 10.2 now has a category of transport vehicle, which is specific. It also has the category of light motor vehicle, which is general, which may have a private motor car, a light transport vehicle, a road roller, an omnibus, etc., various things. That's general. Now, if you need to have a license to drive a transport vehicle, my submission is that you will fit into the special part of 10.2, which is the transport vehicle, and not be covered by the general. The general will exclude something which is specifically provided separately. I'm not citing another Constitution bench judgment for this proposition. There are several. That is 1979 3 SCC 347. It's called State of Gujarat versus Patel Ramji Bhai Dana Bhai. Constitution bench headed by Chief Justice Chandrachud, the senior. And I'll just take your lordship to a few paragraphs. Paragraph 3 first. Paragraph 3, my lord, of this judgment. The common question posed for our decision in all these appeals is whether any of the provisions in sections 33, 6 and 35 of the Bombay Sales Tax Act, which are in para materia with section so-and-so of the Bombay Sales Tax Act 1953, the earlier act, offend Article 14 of the Constitution and as such are void. The High Courts, tribunals and the concerned appeals have answered this question in the affirmative, namely saying that it's arbitrary because you can invoke either of the two sections for a particular class of cases. Your Lordship may have paragraph 12. By a common judgment, dated 8 July 1970, the Gujarat High Court held that the provisions of Section 33(6) and 35 overlap each other because all cases of escapement of assessment by a dealer can be dealt with at the sweet will of the assessing authority. Under either of these provisions, that a dealer who is subjected to the procedure provided in Sections 33(6) will find it more onerous than the one in Section 35, inasmuch as unlike the latter section, no period of limitation has been provided for taking action under Section 33(6). No guidelines have been provided, and the choice of one procedure in preference to the other is left to the arbitrary whim of the assessing authority. On this reasoning, the High Court held that Section 33(6) offends Article 14 of the Constitution.
This was that old line of authority, Northern India caterers, that when
Absolutely.
there is a more
Sarkar and all
rigorous
that.
procedure and a general procedure, then
And-
that violates Article 14.
And you
then,
have
of
a
course, it
choice
was
of
overruled.
going to
68
either
was
or.
overruled in 74.
Correct.
Yeah.
Your Lordship may then have paragraph 23 where the sections are set out.
How did they actually formulate it? Let's see how they formulate it. Just
relevant
shows of just a relevant
principle, right?
formulation,
The
the principle.
Yes. But just have paragraph 26. In fact, 25. An analysis of sections 33(6) of the 1959 Act corresponding to section 14(6) of the 1953 Act will show that it applies to that particular class of dealers liable to pay tax who, 1, fail to apply for registration as required by law, and 2, fail to pay the tax in respect of any period. Thus, 33(6) is in terms restricted in its application to the case of unregistered dealer whose modus operandi to evade tax involves ab initio disregard of the law. It does not apply to a registered dealer who has escaped assessment or has been under-assessed or assessed at a lower rate, or has been wrongly allowed any deductions, or has concealed any material particulars relating to sales or purchases, or has knowingly furnished incorrect
Yes,
returns.
got it. Yeah. Yes, Mr. Bhushan, we've seen
We'll
that.
go to the next.
We'll go to the next.
So then it goes on to cite the principle.
So according to you, transport vehicles were brought in by amendment in 1994.
Correct.
Therefore, the general category of light motor vehicles would necessarily therefore have to be construed as excluding transport
vehicles. Because if you want to drive a transport
And
vehicle,
the definition is always unless something to the contrary appears in the text of the statute.
Right. So this is totally not apart from the section.
That's the second reason why you have said that.
That's the second reason.
What is the next point now?
Now, Lord, the reason for exclusion of transport vehicles from the license to drive an LMV, that you need a specific authorization, what is the reason? I mean, why have they done this? Please have a look at what transport vehicles are. See the definition. (247), page 318. And not just to sort of continue with the last one about that 10(2), the special and general. Mukul Devangan deals with it by saying that 4 categories were removed and transport vehicle was added. That is medium, passenger and goods, heavy, passenger and good. These were the 4 which were removed and transport was added. Therefore, my Lord, Mukul Devangan says, therefore the entry transport vehicle there would be deemed to be only medium or heavy transport vehicles, because you have replaced those 4 with transport vehicle. Those have been deleted and transport vehicle has been added. Therefore, it will be deemed that transport vehicle as added in 10(2)(e) now will only be medium or heavy.
Those which were excluded.
Those which were excluded. Now, Lord, it doesn't say, the entry doesn't say transport vehicles other than light motor vehicles. It just has transport vehicles, all kinds. Now, merely because 4 were excluded.
That's the point.
You have to tell us the
Yes, 247.
reason for excluding.
Correct. transport vehicle means a public service vehicle, a goods carriage, an educational institution bus, or a private service vehicle. Now just see the definition of public service vehicle, which is not 35. Just before this. Means any motor vehicle used or adapted to be used for the carriage of passengers for hire or reward, and includes a maxi cab, a motor cab, transport carriage, and stage carriage. So you're carrying passengers. Normally, in a private car, you're carrying yourself and people who know you, and therefore who can trust you. But here you're carrying passengers who don't know you. You may be driving a bus, you may be driving a school bus. And therefore, people, strangers to you, are putting their lives in your control. And therefore, my lord, the licensing provisions are much more stringent. Get a license, you must be at least 20, you must have that kind of
Yes.
maturity. The license will be given only for 5 years, it will have to be renewed every 5 years. Unlike not a light motor vehicle, which will be valid up to 40, it could be valid for 22 years. You get it at 18. You have to have a medical examination and a certificate before you get a license, unlike modern light motor vehicle.
Yes.
So why is all that? Why is there a stringent blood mechanism for transport vehicles? Because you are putting others at risk. Or in the case of goods vehicles, because it also includes not goods vehicles, who are driving normally for very long hours. Truck drivers drive for very long hours. So again, my lord, that's according to me, the rationale for having a totally different regime for licensing of transport vehicles, or for granting a license enabling you to drive a transport vehicle. Now, my lord, just come back to 3.1, which is why certain kinds of transport vehicles are excluded from that specific authorization. And no person shall so drive a transport vehicle other than a motor cab or motorcycle hired for his own use. So a motor cab may be a transport vehicle, but if you hire it for your own use, then you're not putting others at risk. Motor cab is a transport vehicle. Your lordship may have a look at, my lord. The definition of motor cab means any motor vehicle constructed or adapted to carry not more than 6 passengers, excluding the driver, for hire or reward. So you may hire a car, but you want to drive it yourself.
Excluding the driver
Ah.
for hire.
Correct. So why is this exclusion from transport vehicle? Because you're not putting others at risk.
When you use your personal car as a Ola,
Correct. No, the reverse. When you use a rented vehicle, when you use your personal car as an Ola, then you have to get a transport vehicle license. Absolutely right. But when you use a rented car for your own use,
For your own use.
then you
For your
don't
own
need a
use.
transport
You're not
vehicle
carrying
license.
outside.
you don't need to.
Yes, absolutely right. So that is, my lord, my third point, namely that's the rationale for having a separate regime, separate syllabus, separate age, separate validity of license, medical certificate, all those provisions which my learned friend pointed out, my lord. And how do you reconcile the two? Supposing this judgment was right, each and every one of them you'll have a problem. I can get a LMV license without, my lord, a medical certificate. And then I can, according to the judgment, I can then drive a transport vehicle with it. But the section says you cannot get a transport vehicle license. You can't drive a transport vehicle unless you do all this. You get a medical certificate. I can get a license at 18. I don't need to renew it, my lord, till I'm 40. How do you reconcile all this? It doesn't say that if your LMV is license is going to be used for transport vehicle, then you must get it renewed every so many years. My license will only say LMV. And according to this judgment, I can drive a transport vehicle with it, provided it's under 7,500 kilos. Then, my lord, I don't need to get it renewed every 5 years, despite the provision. I can drive it at 18. I can get a license without a driver's license. How do I, my lord? If the provision says you can get a learner's license for a transport vehicle only if you had a license, a real proper license for a LNV for 1 year. But in the same breath, this judgment is saying if I have an LNV license, I can drive a transport vehicle. All these lot become contradictory, all these sections. There is a section 9(4). I'm unclear, Lord, as to whether your lordship had seen it earlier. Just have a look at that also.
Can we come back at
Yes.
2 o'clock?
Lordship, please. Lordship, please.
What is section 9 for? What page is it? PDF?
Yes,
320?
1.
Yes. What is 9
Now,
for?
9 is grant of driving license. Now, if your Lordship has 9.4 straight away, where the application is for a license to drive a transport vehicle, no such authorization shall be granted to any applicant unless he possesses a driving certificate issued by a school or establishment referred.
This is the way I had shown us.
Yes. Now, I just want to make one point about it. Your Lordship will notice the use of the word authorization. It doesn't say license, because the section itself is about license, grant of license. Now, this is pre-1994. This subsection predates the 1994 amendment. So section 10 at that stage did not have a license for driving a transport vehicle. It only said in section 3 that whichever category your transport vehicle fits in, you will have to have an authorization granting you to drive a transport vehicle. So this fits in with my construction of 3.1. Namely, if you want to drive a transport vehicle, irrespective of what category it fits in, just a license of that category is not enough. You must have an additional authorization to drive a transport vehicle. And this can't be given unless you have a certificate, driving certificate issued by a school, driving school, which is not required for light motor vehicle, which is not a transport vehicle.
Yes.
Now, I just want to make one more point, and that is again relating to section 10. Your Lordship has seen that Mukund Devangan says that because a transport vehicle is included in the definition of light motor vehicle, therefore a license to drive a light motor vehicle shall include the license to drive a transport vehicle.
Right.
Now, the same reasoning applies to road roller, because light motor vehicle also includes a road roller which is less than 7,500 kilograms.
Right.
Now, just consider, road roller was there in section 10.2 initially also, 10.2I. It's still there, was there initially also. Therefore, if you carry the logic of Mukund Devangan, if you get a license to drive a light motor vehicle, you can drive a road roller also, so long as it's below 7,500 kilograms.
But this will be much more than that.
A road roller drives totally differently than a normal car. Turning it, etc., is all going to be totally different. Now just have a look at section 9.3. Before you get a driving license, you must have a test. If the applicant passes such test as may be prescribed by the central government, he shall be issued the driving license. Now this test, your Lordship will find, Rule 15 says, Rule 15.
Which provision was this?
9.3.
9.3. So before you get a driving license, obviously you have to pass a test.
Yes.
Now, what vehicle do you drive for the test? That is prescribed in Rule 15.2. Page 443. The test of competence. Does your Lordship have that one?
Yes.
The test of competence. This is under the heading driving test. The test of competence to drive referred to in subsection 3 of section 9 shall be conducted by the licensing authority or such other person as may be authorized in this behalf by the state government in a vehicle of the type to which the application relates. Now, supposing your application is for a light motor vehicle. You go in a Maruti 800 car. You pass the test. You don't drive a road roller. Can it be said now you're authorized to drive a road roller? Even though that's a totally different category under 10.2. If you follow Mukund Devangan's logic, then you can even drive a road roller now. So surely, if you want to get a license for a road roller, you will have to be tested on a road roller of the vehicle of the type to which the application relates. So
Right.
therefore, another odd reason showing how the logic in Mukund Devangan is totally flawed. And again, reiterating, this will be covered by that Generalibus Specialia derogant. Namely, if something is there specifically, it will be deemed to be excluded from the general.
What else now?
Yes. Now, Lord, just one very quick point, and that is, Lord, possibly the one thing that may have weighed in the mind of the court while deciding Mukund Devangan possibly could have been that the insured may be benefited if the insurance policy is still valid, despite the fact that it's not specifically authorized to drive a transport vehicle. But what they didn't notice is that this will jeopardize other road users. Namely, if you permit somebody who has just a light motor vehicle license and permit him to drive a transport vehicle, 7,500 kilos is actually quite large. I mean, the normal car, a Maruti 800 is less than 1,000 kilos. A reasonably large, like a Fortuner or something, is about 2,000 kilos. So 7,500 would be a medium-sized bus. Now, to permit somebody to drive a medium-sized bus, even though he has been tested on possibly a Maruti 800 car, would jeopardize other road users. So, while on the one hand, you may be saying that, all right, this will benefit some insured who would otherwise lose the benefit of that insurance. But on the other hand,
But you're speculating on the reasoning, possible reasoning.
possible.
That is
Yes,
not
yes.
indicated.
I'm
in
only
your-
saying, Lord, that in case this issue arises, the fact of the matter is that, of course, we have to go purely by the act. But in sort of benefiting some persons who may otherwise lose insurance, we can't jeopardize other road users by permitting people who would otherwise not be competent to drive that vehicle, especially in view of the specific exclusions under 3.1, etc. Now, Lord, just one thing I want to say, which may not be related with the outcome of this case, and that is that amendment of 1994. If your Lordship sees, Lord, all those medium, heavy, etc. have been removed, and they have all now been brought under the umbrella of transport vehicle, irrespective of the weight. Now, transport vehicle could be a small, one of those three-wheeler goods carriers, which may be reasonably light and very small. It may be something with a trailer carrying a container, which is huge. Now, your Lordship has seen under section Rule 15, section 9.3 and Rule 15 that you are tested on the kind of vehicle that you are applying for. You are applying for a transport vehicle now. You may be tested on one of those small little things, something which is colloquially called the chota hathi. I don't know if your Lordship has heard that phrase. The very small three-wheeled goods vehicle. You may be tested on that, and then you become licensed to drive a huge trailer with a container. Now, earlier that was not the case. So this amendment may be ill thought of, because you may be tested on a very small vehicle and now you're permitted to, of course, it doesn't make any difference to our case. Well, our case doesn't depend on that. Just a small aside that I'm pointing out to your Lordship, Lord, if your Lordship feels that something needs to be said about that.
Thank you, Mr.
I'm very, very grateful to you.
Thanks, Mr. Bhushan. Thank you. Yes, Mr. Kaul.
Just one last thing, Lord.
Yes, sure.
And that is question that may arise is, why do you define light motor vehicle with all these different classes? And the answer may be, Lord, in Rule 34. Because different fees are payable for a trade certificate based on whether it's a light, medium, or heavy. Rule 34 read with Rule 84 and the table with Rule 81, which is the fees chargeable. This is for a trade certificate. Very grateful to you, Lord.
Yes, Mr. Kaul.
May please. Ultimately, the issue is not whether transport vehicles are included in the definition of LMV. The issue is whether the holder of an LMV vehicle, simpliciter, is entitled to drive all vehicles within the scope of section 2 subclause 21 without any specific endorsement, without any application, test, eligibility, age requirement, medical certificate at all. So simply because you have an LMV license is enough for you to drive all vehicles under section 2 subsection 21 is the mistake, with all respect that I say, is committed in Mukund Devangan. And this error, my lords, occurs because what the court does is to say that under section 2 subclause 21, LMV includes transport vehicle, and even after the amendment of section 10 subclause 2 subclause D, LMV still stands as an independent category, quite apart from the transport vehicles which consolidate heavy and medium vehicles. Thus, simply by having an LMV license, you can drive a transport vehicle within that category. That's where the error lies. Completely ignoring, my lords, that the light motor vehicle definition under section 2, subclause 21, is a broad definition based on weight and includes all kinds of transport vehicles. It's a general definition which is weight based. But that does not imply that the licensing regime or the eligibility restrictions for all kinds of LMVs remain the same. That's the error. It's a general description, a definition which is weight based. But to say that the entire licensing regime, all the eligibility conditions now need to be that of an LMV and not of a transport vehicle is the most fundamental error which is committed in the judgment in Mukund Devangan. And my lords, which your lordships have now repeatedly heard, and also observe. The issues involved of public safety, of much longer hours, duration, hazardous goods, interaction with far more passengers, congestion, many of those issues come in. Why transport vehicles and their eligibility conditions, the licenses to be taken, medical certificates, all are put as stringent conditions there. Those are the essential differences. Now, even my lords, as far as the forms are concerned, because please have form 7 of the compilation which Mr. Dave gave at page 881, form 7.
Sir, may I have your lordship's leave?
Yes, yes. Okay.
And it's this compilation which Mr. Dave gave in the morning. Please have page 881.
Different form with.
My lords have page. I mean, let's kindly see even issue date, validity, NT, validity, transport.
Yes.
Provided there. Please have the other page, 882. Class of vehicles, there's a two-wheeler, there's a car, and it all says light motor vehicle, transport, and then again categories, please see NMV, could be a transport or could be a non-transport.
Yes.
The categories are provided there.
Right. That is
Now to say that I have an LMV license and thus I'm entitled, even I was looking at my old license, which was 2018, before the 2019 amendment came in. There it simply said LMV, but below it said validity T, in my case, non-applicable, validity NT, and the date was due, non-transfer. So this has inherently always been there given the scheme of the Act. Now kindly see this with the form also in form 4 that used to be there, form 6 which used to be there in Mukund Devangan. Please have page 78 of this very compilation.
Also.
Your Lordship, be kind enough to have page 79.
We were just talking about the stick shift age, you know, the stick shift gears.
Yes, yes, yes.
Today's generation will not know what they are.
Everybody is used to automatic.
But things have a knack of coming back. We never know. Someday it may become the fashion again to drive those cars.
Like the turntable.
Like the turntable. Would your Lordships be kind enough to have page
Turntable have become
79? Page 79. Now, this was the form in Mukund, Devangan, my lords. And please see somewhere in the middle, a motor vehicle of the following description. First, the descriptions are given, and then a motor vehicle of the following description, license to a driver or motor vehicle other than transport vehicle. And on the right side, license to drive transport vehicle. And then below it, authorization to drive transport vehicle. So there has always been a specific authorization.
We had seen that actually earlier.
Now, my lords, I'll quickly just sum up 2 or 3 provisions and the crucial errors as I see in 3 or 4 paragraphs, and I'm not going to trouble your lordships with the paragraphs again. Para 17 of Mukund Devangan, my lords, as I had respectfully submitted to your lordships, commits the error of saying that because under 2 subclause 21, LMV includes the transport vehicle, and since under section 2 section 10 subclause 2 subclause D, it still retains its position under
That you said,
D.
yes.
Thus, a license is enough. The next error is para 21, my lords, where the court goes on to say that an amendment would be required to bring the transport vehicle outside the category of LMVs. And since that is not done by the legislature, a transport vehicle of a light motor category does not require a separate registration. Now, one of the 2 fundamental errors in that are that no one is denying that transport vehicle below a certain weight is including in the LMV category. The problem doesn't lie there. The problem lies in your applying the same licensing regime and eligibility criteria to transport vehicles, not of a certain weight being categorized under the LMV category. So there is no amendment required. It can surely be because LMV below a certain weight covers many things, covers many kind of vehicles. Thirdly, my lords, again in para 21, the error is that the intent behind the 1994 amendment is again referred to say that they retain their separate positions. Thus, a category of a transport vehicle which covers heavy and medium is separate from the category of a transport vehicle which covers LMVs.
Yes.
That's the third point given.
What is the third point?
The third point given is, my lords, that the intent of the 1994 amendment
Yes.
was to combine what used to exist in 10 pre-amendment, that is category E to H, in order to create 2 separate classes of transport vehicles, one covering heavy and medium, and the other covering vehicles weighing less than 7,500 kgs. Completely ignoring the fact, my lords, that knowing fully well that LMVs include transport vehicles below 7,500 kgs under section 2 subclause 21, the legislature still retains LMV as a category and retains transport as a blanket category. Now, if the legislature intended that this will only cover heavy and medium, the transport, it could have specified it therein. It doesn't do that. And rightly doesn't do it because eligibility conditions, requirements are all different. So all that is done is a simplification of procedure. All transport vehicles at one place, light motor vehicles at one place. Now to correlate it and say 221 LMB covers transport and thus nothing requires is the error. Next, my lords, is para 25. Which completely ignores section 14 of the Act, where different validity periods are provided. And it again embarks and says that this is only in the form. The form cannot override the statute. And these validity periods will only apply to heavy and medium transport vehicles as contained post amendment to section 2 subclause 2 subclause DNA. Completely ignoring 14 of the statute, which deals with validity periods for various provisions, for various class of vehicles. Now, my lords, if this judgment is seen as it has the effect of completely obliterating the requirements regarding user or intended use. And I'll end, my lord, with those 4 or 5 statutory provisions again. Because as I see it in all humility, the Act is user-based, is utility-based. It's the usage which is to be given importance. It picks up a section, the weight contained therein, and completely obliterates the requirement of usage. And lodges have again and again seen these sections, but just 4 sections, if your lodges were to have for a minute. And I'll just run through those 4 sections and I'm done. Section 2, my lords, for a minute. Driving license means the license issued by a competent authority.
Section 2, which is a provision?
Subclause 10, page
Yes.
360.
Yes.
Mr. Dave's compilation.
Yes, driving license.
Driving license means the license issued by my lord the Chief Justice.
Yes.
A driving license means the license issued by a competent authority under Chapter 2, authorizing the person specified therein to drive otherwise than as a learner a motor vehicle or a motor vehicle of any specified class or description. Then Section 2, subclause 21. Light motor vehicle means a transport vehicle or omnibus, the gross vehicle weight of either of which, or a motor car, or tractor, or road loader, the unladen weight of any of which does not exceed 7,500 kilograms. Now, my lords, Section 2, subclause 47, which is on page 318. And I should have given the page. Actually, Section 2, subclause 21 is on page 317, and Section 2, subclause 47 is on page 318. Please have Section 2, subclause 47. Transport vehicle means a public service vehicle, a goods carriage, an educational institution bus, or private vehicles. Now, my lords, each of these, the public service vehicle is defined in Section 2, subclause 35. Private service vehicle is defined in Section 2, subclause 33. Goods carriage is defined in 2, subclause 14, and educational institution bus in Section 2, subclause 11. Now, my lords, each of these categories, please see the terms they employ. The terms employed are used, adapted to be used, adapted to be used, constructed, or adapted for use. Clearly showing that the category of transport vehicles is entirely based on the use of the vehicle and not on the weight of the vehicle.
Used, adapted to be used. You said constructed?
Used, adapted to be used, or constructed or adapted for use. Each of these are clearly based on the use of the vehicle, not on the weight of the vehicle. And as that example has been repeatedly given to your lordships, there could be a vehicle of less than 7,500 kg with hazardous goods, school children being ferried. So many instances, long hours on the road. So do we obliterate all those restrictions and conditions as contained in the statute? Then, my lords, the next section is section 3.
Since it's user based, it's not user based.
Section 3, subclause, section 3 on page 319. No person shall drive a motor vehicle in any public place unless he holds an effective driving license issued to him authorizing him to drive the vehicle, and no person shall so drive a transport vehicle other than a motor vehicle or motorcycle hired for his own use or rented under any scheme made under subsection 2 of section 75 unless his driving license specifically entitles him to so to do. Read with my lord section 10 for a minute, and then I'm done as far as the statutory provisions are concerned. Do we have the... No, we don't have that. In fact, my lords, I'll also hand over the pre-amendment section 10 because that may be of some assistance to your lordships to say that earlier, my lords, the category of light motor vehicle remains. E to H, as they earlier were medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle, and heavy passenger motor vehicle. That E to H were combined to make them into transport, which came in the new.
Right.
And that which I respectfully submitted is can't be read to me that light motor vehicle has been retained, and since under 221 it includes transport vehicle, a new category is carved out of a light motor vehicle which is a transport vehicle of less than 7,500 kgs, not requiring any of the things of eligibility, etc., which are required to be done, which could not be so. Lastly, my lords, a few judgments I'll just leave with your lordships, which have already taken the view that we are today canvassing before your lordships. And I'll just leave those two judgments with your lordships. Just two judgments. These two, right? My lords, one is New India Assurance Company Limited versus Prabhulal, 2008, Volume 1, SCC 696, paras 42 and 43.
Whose judgment is that?
Manoj, it's part of the compilation, page 118 to 133.
Okay.
And then second is Oriental Insurance Company versus Angat Cole, 2009, Volume 11, SCC 356, paras 13 to 16. This is in the compilation, pages 139 to 146.
And the first one?
First one was in the compilation, pages 118 to 133.
Yes.
And both my lords before Mukund Devangan had differentiated between the two kinds of licenses, the two kinds of classes of vehicles, the eligibility requirement, both had dealt with it.
Yes.
Now, my lords, I am not revisiting, since your lordships have repeatedly seen all those conditions on age, qualification, the that you must have, even before a learner as a transporter, you must have a license. All those conditions which have been repeatedly shown to my lords.
Yes.
And thus, my lords, to say that an LMV, to end to say that an LMV, merely because it covers on a weight,
Right.
a transport vehicle requires no other requirement to make you eligible to drive a transport vehicle, would be completely contrary to the statute. And as your lordships in ERA and many other judgments have held, the text and the context has to be seen. A purpose of interpretation, a harmonious construction is what your lordships will see, and not a interpretation which renders large parts of the provisions odious or obliterates a very important part in the scheme of the act and defeats the object of that. I'm very, very grateful, my lord.
Thank you. Thank you, Mr. Bob.
I have nothing further to add. I'll take only 5 minutes, my lord. Because one angle, my lord, which may assist your lordships even in arriving at a correct conclusion, my lord. Lord, your lordships would find from the general architecture of the act, the sine qua non or the intention of the legislature under every provision is the safety of the one who drives and safety of those who are affected. The passengers or people not on the road.
Yes.
Lord, keeping this overarching parameter or in legislative intent in mind, the Act is divided into several regimes, one of which is licensing regime. Now, before I show, Lord, only 3 sections in my submissions would be over. Lord, kindly once again visit section 10. If section 10. Lord, your lordships would bear in mind, your lordships have been repeatedly shown section 221 that light motor vehicle means transport, includes transport vehicle. But for the purpose of the first regime, namely licensing regime, both are separately provided. Your lordships have not seen that.
Yes.
Under 10(2), D and E, legislature had no necessity to separately provide. It could have said light motor vehicle, which in any case would have included transport vehicle.
Yes.
Then the question would arise, why section 221 provides for a separate weight? What is the significance? What is the statutory importance of the term weight? 7,500 and 12,000 respectively for light and heavy motor vehicles. Lord, that is for a different regime, which my lords would find from section 130. Again,
Yes.
kindly come to section 113 of the Act, my lords. 113 Motor Vehicles Act, my lords. This is another regime, of course, taking care of the safety, but not licensing regime. And that is where, my lord, the weight comes. The state government, your lordship gets.
So Solicitor, today you forgot your iPad at home?
I'll read, my lord. I beg your lordship's pardon, my lords. But I didn't even realize that I'm already continuously committing.
You have to constantly goad everyone.
Old habits die hard.
Yes, I'm so sorry, my lords. Lord, please see section 113. But now I have learned, my lord, under the
Yes.
the state government may prescribe the conditions for the issue of permits.
My learned brother says, when you said I've learned, my learned brother said, under your coercion.
Not coercion, my lord, I wanted to say. My lord, the way I stopped at the word under, my lord, may lead to that, but that was not intended, my lord.
Yes.
The state government may prescribe the conditions for the issue of permits for transport vehicles. Please see, my lord. By the state or regional transport authorities and may prohibit or restrict the use of such vehicles in any area or route. Your lordship knows, my lord, in some of the areas, transport vehicles are prohibited.
Right.
And here comes the weight part. Please see, except as may be otherwise prescribed, no person shall drive or cause or allowed to be driven in any public place any motor vehicle which is not fitted with so and so. No person shall drive or cause or allowed to be driven in any public place any motor vehicle or trailer, the unladen weight of which exceeds the unladen weight specified in the certificate of registration. Lord, there can be an area where there is a prohibition of driving any vehicle which is more than 7,500. Lord, your lordships would find section 114, I am not reading. It confers power on the statutory authority to get it weighed if someone disputes. But please see 115. Here also, my lord, the weight comes, whether my vehicle is a light motor vehicle, which may include transport vehicle or not, but distinction would be that of weight. The state government or any authority authorized in this behalf by the state government, if satisfied that it is necessary in the interest of public safety or convenience or because of the nature of any road or bridge, may by notification in the official gazette prohibit or restrict, subject to such exceptions and conditions as may be specified in the notification, the driving of motor vehicles. Here, my lord, the weight can be the consideration. That motor vehicle, light motor vehicles, except transport vehicles are not permitted because it has weight of 7,500 and the bridge is in a dilapidated condition. Or any specified road, and when any such prohibition or restriction is imposed, shall cause appropriate traffic signs to be placed or erected under section 116 at suitable places, etc. My lord, then rest are, my lord, supplementary provisions to that. So, my lord, weight has its own importance in a separate regime, but section 10 says, so far as licensing is concerned, we give a separate license for light motor vehicle, and though transport falls within that, we give a separate license for transport vehicles. My lord, my learned friend has, my lord, just, my lord, one last minute. My lord, in my written submissions, my lord, there are some, my lord, your lordships are orally already informed, page 82 of my written submission.
All right, Mr. Solicitor, we'll take a little liberty with you. We'll hear Archana on that part.
Please, your lordship, kindly do
Come
that.
on, tell us, Ms. Dave, what do you have to say? Thank you, Mr. Solicitor. Thank you. Thank you. Thank you.
Submissions that my learned Solicitor General Senior was showing, well, as we have attached some photographs. If my lords would kindly come to the submissions of learned Solicitor General, my lords. Annexure A4, my lords.
Final written submissions?
Yes, my lords.
Lecture A4 you want to say?
Yes, my lords. Those are bookmarked, my lords.
Bookmarked, correct.
Yes, my lords.
Okay. Union of India versus Dilip Kumar Singh.
No, it's the final written submissions, page 82, my lords. There are pictures, my lords.
Like this.
This
Honorable Chief Justice.
She has got.
clear from that.
My lords, so this, my lords, the first picture, my lords can see it's a school bus. And the weight, the gross vehicle weight is 7450 kg. So going by, my lords, what Mukund Devangan says, it means that anybody who's holding an LMV license would be able to drive this vehicle. So, my lords, it is basically the use for the licensing regime. It is the use which is important. As it was also discussed earlier, weight can also be for tax purposes, like my learned senior Mr. Dave pointed out. And also with regard to which road you are traveling, as my learned senior Solicitor General just now pointed out, in section 113, 114 and 115. But my lords, only to see that 221 has to be seen for the licensing regime, in my most humble submission, my lords, is contrary to the statute and rules, as we have already seen.
Yes.
Well, so similar are the other pictures that I have put, my lords. It is again a school bus. The gross vehicle weight is 5,900 kgs.
Visual impact. Yeah, right.
Well, as when we talk about the harmonious construction of the statute, it means that if, well, it's, you have to read the statute as a whole. So when there is one provision which is going contrary to all the other provisions, then a harmonious construction of the statute with regard to what purpose it is defining. So maybe the definition clauses with regard to the weight, because there they are saying that maybe a light motor vehicle can mean a transport vehicle, and they have prescribed a weight. But whereas in chapter 2, section 3 clearly says that it is the use of the vehicle, and the second part, whereas the second part is in fact a negative covenant, which is saying that you cannot drive a transport vehicle. Well, these are my submissions. I have also, my lords, filed another submissions saying the judgments on harmonious construction. Well, it's additional written submissions. I don't
Not
want
necessary. You can on the we'll
I
check out GPC.
cut out the paragraphs for my lords.
All right. Thank you, Mr.
Deeply
Dave.
obliged.
Thank you. Thank you, Ms. Dave.
Just 3 minutes, minutes. Minutes. I represent this.
For the
Minutes. I
on
am
the same side as this?
Same side.
All right. For the insurance company or?
not for an intervener, minutes. I represent a society, minutes, which helps road accident victims. And minutes, it's called as the Society Against Drunken Driving. Minutes, my IA number is 13309/6 of 23. Minutes, the point that I am making is, minutes, this honorable court has looked at road safety as a fundamental right under part 3. It has specifically recognized it to be a 21 right. And my lords, having recognized those 2 paragraphs of the judgment, my lord, which says that road safety is a part of a 21 right, if you read it as a 21 right, my lords, my submission would be Mukund Devagan on the road, my lords, in real terms, would be an antithesis to road safety, because it completely obliterates section 7, makes it OTOs. Under these circumstances, my lords, section 7 has to be read as a safety measure. My lords, suppose that judgment, my lords, that is the judgment on Life Safe Foundation, 124A was introduced as a safety measure, where, my lords, people, bystanders who are called as good Samaritans, who help people, my lords, because normally the tendency the judgment recognizes the fact that people don't come to help road accident victims at all because of the consequences they face with regard to investigation and interrogation. They are supposed to go to police station. Therefore, the court had laid down the guidelines and said that till the vacuum is cleared by a statute or a regime which recognizes the right of bystanders not to be called as a witness, or rather they are, instead of being called as a witness to the police station for interrogation or during court, what they are supposed to send a commission to them, help these people. In fact, my lords, in US there is some, in UK, my lords, there is something called as a heroism act, where, my lords, a person who helps a victim is in fact considered as a hero, and thereafter, my lords, they are given certain special recognition by the society itself, so that this sort of road accidents or in a way, my lords, stopped, or at least, my lord, to extend. Now your lordship may kindly see that judgment, that is, my lords, 2016 7 SCC 194, which considers it as a part 3 right. 2016 7 SCC 194. Lordship may kindly look at page 208. I just read 2 paragraphs. Your Lordship got it, right? 208.
Which paragraph?
55 minutes. 56.
Yes, we saw that.
Yes.
55.
56 minutes. I repeat
56.
56 and then 58 minutes for this. The Department of Road Transport is responsible for framing motor vehicle legislation and evolving road safety standards in India. WHO, my lords, it's also a part of India's international obligation. WHO, in its World Report on Road Traffic Injury Prevention 2004, has projected that by 2020, road accidents will be one of the biggest killers in India. It is also emphasized that in low-income countries, the most common desisting factor restraining the public from coming forward to help victims is the apparent fear of being involved in police cases. There is need to build confidence amongst the public to help road accident victims. Bystanders should not be insisted to divulge their personal particulars or detained in the hospital for interrogation. People are hesitant to render immediate help to the road accident victims. The victims lay wounded on the road for some time till the arrival of police. Delay in rendering medical help in such cases sometimes is fatal. Good Samaritans have the fear of legal consequences, involvement in litigation, and repeated visits to police stations. There is urgent need to tackle these issues. There is need to establish legal framework so that a good Samaritan is empowered to act without any fear of adverse consequences or harassment. Saving life must be the top priority. Several countries have enacted such laws. Now your lordship may skip over and come to paragraph 57, my lords, at page 209, where they say it's a part of a part 3 right. Lordship got me?
Yeah.
Accident cases require fastest care and rescue, which could be provided by those closest to the scene of the accident. Bystanders' clear support is essential to enhance the chances of survival of victim in the golden hour, that is the first hour of the injury. As per the WHO India recommendations, 50% of the victims die in the first 15 minutes due to the serious cardiovascular or nervous system injuries, and the rest can be saved through by providing basic life support during the golden hour. Right to life is enshrined under Article 21, which includes right to safety of persons while traveling on the road, and the immediate medical assistance as a necessary corollary is required to be provided, and also adequate legal protection and prevention from harassment of good Samaritans to good Samaritans. Therefore, my lord, this contemplates the realistic situation that exists today. And therefore, my lord, this court found that there is a vacuum, brought it within the regime of Article 21. Otherwise, there was a legal vacuum here. Brought it under the legal, within the purview of 21. And thereafter, my lords, this led to an amendment. The lordship may kindly see 124A of the Act minutes. Not an amendment, not a new incorporation. I'm sorry. 134A. Protection of good Samaritans.
124.
134A.
Oh, 134.
I'm sorry. 134, capital E.
Calls us.
Yeah.
A good Samaritan shall not be liable for any civil or criminal action, for any injury to or death of the victim of an accident involving a motor vehicle, where such injury or death resulted from the Good Samaritan's negligence in acting or failing to act while rendering emergency medical or non-medical care or assistance. But he is not visited with any civil consequences or even criminal consequences, a direct fallout of this judgment. And two, my lords, the central government may, by rules, your lordship may ignore this, come to, my lords, the explanation of this. For the purpose of this section, Good Samaritan means a person who in good faith, voluntarily and without expectation of any reward or compensation, renders emergency medical or non-medical care or assistance at the scene of an accident to the victim or transports such victim to the hospital. So, my lords, this is a safety wall, this is a safety measure. And my lords, if you contradistinct it with section 7, my lords, which, my lords, today, which is totally a non-safety measure, which takes away, because section 6, 7, my lords, clearly makes a distinction. Well, just visualize the situation where any of us who are having a normal valid license, taking bus children to the school, or my lords, taking a road roller. But these situations are situations, my lords, which fall foul of 140-21, and it should be considered as a safety measure or a, my lords, a safety section or a safety valve section. Semantics do not matter, but the fact remains that section 7, more than the semantics, has a bigger role to play, my lords, seen in the context of Article 21 as well as 124 capital A, my lords. 124 capital A came subsequent to 7. Therefore, I recognize the principle that the regime has to be strengthened with regard to making it more stronger, so that it's better, easier, I mean, safer for the people, rather than section 7, my lords, should not be made.
Thank you.
Deeply obliged, minister.
Please, Lordship. Lordship, I appear in item number 11, 48 and 51, as circulated by written submissions in item number 11. Lordship, essentially, I'm addressing your Lordships on the issue of the possible scenario if your Lordships hold that the law laid down in Mukund Devangan is not right. I've indicated 3 scenarios, your Lordship. May I please have my written submissions, the question of law which I have formulated. May I read, your Lordship?
Eleven,
11, 48 and 51, ma'am.
48.
May I?
Mr. Solicitor, in our section, in the 370 matter, which will start next week,
Yes,
if you can just make sure that the 2 nodal counsel prepare the written submissions, the compilation with continuous pagination.
yes, ma'am.
They'll have to just, of both sides, with one continuous pagination. It could be in book form, so that, one book could be, the precedents which are relied upon by the petitioners, other documentary material, likewise for the respondent. But let it all be in a continuous pagination.
Yes, yes.
We'll notify guidelines for these matters, because we are also,
Yes, my lord, your lordship, sir.
we are just
Yes.
fine tuning the
But I
guidelines.
today itself, my lord, speak to
The
both
two-
of them.
So that they can sit down and make sure that, where.
We'll sit together and make the pagination so that every pagination tells.
Over the weekend, then, the council is going to open from the other side. Maybe Mr. Ramchandran is opening perhaps. Last time they told us that.
Well, last time, one Mr. Zafar Shah from Jammu and Kashmir, he opened the arguments, and the next was Mr. Rajiv Dhawan.
Oh, I see. But whoever is opening the arguments and then those who follow should have that common pagination, so
Yes,
that
yes. Well,
also
we'll
for your
ensure.
side it'll be much easier.
We'll ensure that. Well, for the respondents, we may have to supplement our written submissions after listening to them. But that doesn't, my lord, it would not come as a last minute, my lord, that 10,000 which your lordship said experience. That's not the idea.
But make sure that both the juniors sit down, the council sit
I'll
down
ensure
and give us,
personally speak to both of them.
and by tomorrow we'll notify the guidelines also, I think.
Yes, yes, my lord. The date is 27, by
27.
which, my lord, we are supposed to do
Yes.
that. It would be done, my lord, accordingly.
Right. That will be nice.
Speak to both of them. Yes, yes.
I said next week by mistake. It's actually, of course, after that,
2nd August, your lordship.
2nd of August. So there's enough time to make sure that the pagination. Yes.
Yes, Your Lordship. My first question is whether the direction given to insurance companies to pay third-party claims and recover the amount from the owner requires reconsideration in cases where an insurance company has a valid defense under Section 149 2A, Roman 2 of the Act. Now, Your Lordship, this is 150 in the new Act after the amendment. Second, Your Lordship, is whether in the present day scenario, insurance companies to avoid liabilities towards the insured are required to prove that the insured was guilty of negligence and failed to take reasonable care while employing the services of a driver. And third, Your Lordship, is whether the law laid down by this Honorable Court in Pappu versus Vinod Kumar Lamba, 2018 3 SEC 208, is in slight conflict with Swaran Singh. Now, Your Lordship, question number B and C, in my respectful submissions, are perhaps the same facets, different sides of the same coin. Essentially, there are two submissions. Your Lordship, the issue of pay and recover. If an insurance company establishes a breach under 149(2), the remedy, Your Lordship, is given the benevolent nature. Your Lordships direct the insurance company to pay third-party claims and thereafter recover from the insured. This principle was doubted by learned two judges, and this issue was referred to larger benches in two different cases. Lordship, may I please have page 69 of my written submission.
But do we deal with pay and recover in this
Yes.
matter?
Why? It will be important initially, Your Lordship, may see the. No, this is, I say
Not a
that.
part of the reference really. Then for us, nobody else has argued that, and for us
I
to
say
then
this,
hazard
Your
into
Lordship,
this.
under,
If
when
there's an independent reference pending on that,
it's
either
been dismissed. The question of law has been kept open. The order issuing notice on 31st October 2017 in the present matter, the lead matter, Your Lordship had framed this question. If I may point out, page order dated 31 October 2017. Please have this.
There were more than pending, but
Why do you say that the present reference becomes necessary
Because, Your Lordship,
for answering this
yes,
question?
I say this because if at all it's held that yes, for driving a transport vehicle, you need an endorsement, the remedy would be pay and recover. If there's a breach, I have established it as an insurance company. After detailed investigation, the trial court concludes that yes, there was no endorsement. What is the sequitur? There is no liability on me. I pay that liability of third
The
party,
answer
and
to
there
that question would not depend upon the interpretation that we will arrive on section.
on the act.
On the act.
But you say the relief would be
That's a
the
different matter.
pay and recover.
We can reformulate the relief,
fact-based issue.
but then on a pure interpretation of the Motor Vehicles Act, whether a second license necessary for transportation, for driving a transport vehicle or not is the only question that we.
Yes,
need to
question,
decide.
but if you Lordship may please see the 31st October.
Whether, the court should, is entitled to pass a pay and recover order.
Yes.
That
Would
really
not
doesn't,
depend on
it
this
doesn't,
interpretation.
it doesn't,
No,
it
but
doesn't
suppose-
arise here.
We did not.
Here,
May I
the
just
insurance
point out-
companies say, the insurance companies like you, we've heard Oriental, you're for National. Insurance companies here are clear in stating that entitle you to drive a transport vehicle. The consequence of that would be that where the driver of the vehicle was driving a transport vehicle, though that person had a light motor vehicle license, that would amount to a breach of the insurance policy. What the consequences is not something that arises here.
And also liability is a different issue, which
Your
we will
Lordship
see
sees
at
the order.
that
If I
point
may
of time.
just point out the order dated 31st October
May have been.
2017. Please have this. The order dated
Mukund,
2017.
really speaking, we are considering the correctness of Mukund Devangan.
Right.
And Mukund Devangan is not really, though I heard Devrat yesterday say that we will argue pay and recover, but really that doesn't arise here.
That's the relief one could get in a third party
But
claim.
that's a matter of relief. That's not a matter of, we are not concerned about
Consider that after this
in an
judgment is
appropriate.
there,
May I just point out?
Is it referred to 5? Is it referred to 3? Or now that is over now?
Well, it's over
It's
now.
over. All of them have been
Questions of law-
dismissed. The questions of law have been kept open. But your Lordships, when issued notice in this matter, had specifically formulated this question, although it doesn't find mention in the 2018 reference order or the 2022 reference order. May I just point out, read that out.
2022 also.
My humble
It doesn't,
submission
it
would be
doesn't.
that we have not addressed at all on this issue and.
As in
this
Mr.
does not-
Mr. Solicitor, a little assistance from you. What do we do about this pay and recover business? Because up to now, in the last one day that we have been hearing, in fact, we are hoping that we'll conclude the hearing today by giving them an hour to address us. Now, this pay and recover, I mean, that has not been argued so far by anybody, and that's not the subject matter of Mukund Devangan.
Yes, but I think nobody has argued because it's not a question framed.
We are not arguing.
And
We were on the
the
different.
question of law, my lord, it seems is kept open.
Why can't
In
that
a
be
given case, he can agitate that question, if need be, can get it referred. If your
Twice
lordship's
it has
final
already
verdict,
been done.
whichever way it
Twice,
goes,
and they've been
helps the
dismissed.
situation.
As
it
far
has-
as the issue of pay.
See, ultimately look at it this way, pay and recover, why do the courts pass that order? The idea is to benefit,
That's right, my lord.
the
Given
most,
the benevolent
most vulnerable section of society. Mostly these are people, who are on the margins of existence, farmers, laborers.
Also, this
somebody
Swarn
lost
Singh
a
judgment has
child.
settled the legal.
Also, the reason where
enter
the
into
court
it
is
here
not
as a
able to
five-judge.
fix the liability on the insurance company or the owner. So keeping that question aside, we would say that immediately pay him because the insurance company has the capacity. But then that question doesn't really depend upon the interpretation that we will have
That's
to
right.
arrive on this case.
Your Lordship, what would be the ultimate
know why-
relief?
how that
Supposing if your Lordships hold that the law laid down is incorrect, that yes, you are required to hold an
Second
endorsement from a
And
trans-
therefore you are not liable.
and therefore you're not liable,
It
but
would be
the
help, you'll be.
That depends on
relief
how
will
what
be,
support-
I cannot be absolved. I
doesn't-
won't be
it's not a
absolved.
acquittal.
The courts would still pass because in Swaran Singh's case.
What would still pass is
A
really
pay
an
and
argument on the facts of a given case.
Yes.
Right, but
There is a
that has
gap
been-
between the
The
decision
legal
that
issue
we will have
already
to
settled
arrive.
by the Swarn Singh judgment, my lordship.
No,
The
that's
legal
why-
issue is already settled by the Swarn Singh judgment, my lordship, with respect to the pay and recovery.
Scenario.
Yeah.
If I can just address your Lordship in 2 minutes, why pay and recover now is not the correct approach, because Swaran Singh was delivered in 2004.
Why it is absolutely necessary. for us
Whenever
to decide
someone
that.
relies upon that Swarna Singh judgment, he may have to argue this and get that issue referred.
It has already been done twice, and it's been dismissed with question of law kept open.
That's the.
Third, for us to take it up.
May I point out, 31st October, if your Lordship sees,
Judgments.
the order dated
Let me, I'll just point out. Oh, दिखाओ तो मैं adding to show that order. तुम दिखाओ.
In your compilation or in Mr. Dave's compilation? Must have kept the question. Where? Which one?
287, 297.
Whose compilation?
The judgment compilation of.
57 is
But my suggestion would be, I'll point out how this may affect. That your lordships can consider framing a question and not left it to be decided on some other day. Please see head note A. How this might perhaps.
297.
297, it's National Insurance Company versus Swaran Singh.
It's not there.
Judgment compilation.
Whose judgment?
Lordship may see.
There is no solicitor's compilation.
It's not there in your compilation.
It's there, my lord. It's there in my submission, page 110. My submission, page 110, if you look.
Okay, we take
Your
yours.
lordships have page 33 of
110, no?
our compilation. My lord. I'm sorry, my lord, page 33. Page
33.
Page 33. My apologies.
इसका है 33.
Head note A.
33, ठीक है.
That is for
Head note A. No, I'm not reading the detail head note. Section 149 2A, duly licensed occurring in section so and so, meaning and construction of, whether different from effective license occurring in section 3. Accident, meaning of and relevance of meaning of to question whether driver duly licensed. Whether a driver duly licensed when not A is license not held, B fake license held, C license held but validity thereof has expired, D may not affect this, license not held for the type of vehicle being driven, and E learner's license held. So 4 may perhaps have some correlation with the question your lordships are not considering.
That can still be.
But at this stage of the arguments, and before I'm not specially constituted bench, the lordship may consider framing this question, answering only whether Devyangna is right or wrong. And my lord, what will be the impact on the Swaran Singh judgment? Can my lord go before another constitution bench? No, that can be one way.
Well, the problem here,
it's
94 regime was in existence for last 30 years. If any new interpretation is given today, my lord, all claims in last 30 years, nobody is getting anything, my lord. Either my lord may give interpretation of prospective effect, my lord, whatever my lord is interpreting, and won't apply to claims which has arisen already. Or my lord may consider giving pay and recover, because then last 30 years, the LMV regime which was in existence and as interpreted in Devangan case, my lord, everyone was getting, insurance company was paying, my lord. And today, if suddenly last 30 years, my lord comes to a conclusion giving a different interpretation just in case, and then all those claims would go, because owner and driver of the vehicle.
Lots of cases are pending consideration following this.
But all these, even today, all these claims.
As far as those which are pending before the Supreme Court, there are no.
Yes, my lord, but across India, my lord, across India, till today, the old regime is going on.
Pay and recover was a part of a social justice scheme, my lordship. Because by way of an amendment, also chapter number 11 is included, my lordship.
So that's on marriage, whether it should
That's
be
on merit, my
here or
lord.
not, that's the question.
But the overall intention of the legislation is to actually, my lordship, to actually have a welfare measure for the victims. So it is for that purpose prayer required and the Swaran judgment, para 50 onwards.
I'm not for a minute suggesting that it has to be a blanket exclusion of pay and recover. If your lordship in a given scenario holds that the law is not right in Mukund Devangan, what would be the sequitur? In cases who someone does not have an endorsement, he commits an accident happens, he will have to pay the third party claim, then recover thereafter. Small people, small tour operators, we are not really concerned. But large scale enterprises, when you can really, on a click of a button, you can verify the contents of a license. I've said so in my written submission. The website's also given. You can just verify. If you verify at the threshold, you nip the bud right there and then. One doesn't need to ultimately go and face the entire litigation. The owner becomes liable. If he makes that call to
You are
verify.
talking about at the stage of engaging the person.
Yes, Manoj. At the stage of engaging.
See, that might be something which would be forthcoming. But what is going to happen for the things which are already not in the Supreme
It could
Court?
be
but
prospective.
all across?
Lordship may say that this judgment will apply prospectively.
Possibly,
Because technically, Your Lordships, when the reference order of 2022, when Your Lordships passed this order, had passed a direction to pay all the claims of insurance companies.
this
2022 order is
question may not
back.
arise. Only a minute. Lord, your lordships, this question may perhaps not arise.
Whether Devangan was right or wrong. And
Correct.
for the present, leave it at that,
I'll assist your lordships why this question perhaps may not arise.
May not arise, of course.
In D, when I read license not held for type of vehicle being driven, your lordships are examining as an interpretative process what is the correlation between 221 and 10. But in practice, when we get the license, I get the license of MV within bracket NT, means motor vehicle non-transport. And for transport, if I want to drive a transport vehicle, I'll get MV within bracket T. So, my lord, so far as this is concerned, if I am driving, my lord, a license, I have a MV non-transport, and if I'm driving transport, then, my lord, I'm not having a license. That's all. Am I clear, my lord? The fourth category may perhaps not arise because the department itself follows the practice of giving two different categories of.
Now tell us one thing, if we overrule Mukund Devangan, suppose, I mean, we have to hear the other side, we overrule Mukund Devangan, there would be cases which are pending across India today on which the entirety of Devangan would...
general trend of the tribunal.
Now, the Devangan regime has also held a field. Devangan itself is of 2017. For 6 years.
Generally,
Government made a notification.
Generally, central government, the tribunals do not give recovery rights. Nowadays, in accident.
Forget the pay and recovery rights. What happens if you overrule Devangan to pending cases?
Recover your lordships is one
So
part.
therefore, we'll have to still have it.
No,
We'll
no.
have to still
My lord, I'm answering.
decide whether we just simpliciter overrule it or say that, well, this is the law which we lay down from hereafter.
It
will not apply to pending case.
It will not apply to
pending
under
case.
section
Because there will be some
150.
element of
Under 100 section 150 subclause 2, one of the valid defenses that an insurance company can take is that the person driving was not holding a valid license to drive that vehicle. All that I'm saying is the implication.
For
If a
proper
license-
overruling, that makes no
Sorry?
difference. That's an interpretation of a statute. The defense can be taken.
Yes.
But then to overrule the judgment, we will also be able, we are entitled to say that
Yes.
will apply prospectively.
Yes, my lord. I'm not saying for a minute.
Paul, you are saying, one second.
That's
So
a
Paul is
submission.
saying
I started with that. It has to be
150,
prospective.
150, it's a valid defense for an insurance company to say that the person who was driving was not holding a valid license.
Yes.
The consequence would be, forget the pay and recover principle. The consequence would be that ordinarily the insurance company would not be liable to the claim by the victim of a motor accident.
My lord, the question would be, as far as that driver is concerned, he could not have driven that vehicle.
Right.
Because an insurance policy is always contingent upon
Of course, that's
the
right.
conditions contained therein. That's all. Because my lord,
The
if it
defense
doesn't
will
put the
be that
question, the
you are
implication
not
was
liable to
Devangan.
pay.
That's all that I'm saying.
Therefore, the consequence for you
Yes.
would be that you can say, I am not liable because, the driver did not have a valid license and there was a breach of section 150 therefore.
And please see, my lords, would an insurance company not be justified in saying so because someone starts employing anyone who starts driving?
We are not saying, one second. We are not saying no for a moment,
Yes.
but all that we are saying is that therefore we may consider as to whether, if we decide eventually to overrule Devangan, whether that should be done prospectively.
Absolutely, Manoj, I bow down to
Bring
that.
about some certainty in the law for the future.
I bow down to that.
It always was this, the law always was this, unless your lordship.
Unless prospective.
Because any declaration is always retrospective by the Supreme Court, unless we say to the contrary.
As far as the pay and recovery aspect is concerned, my lord, law is well settled as on date. That may,
All right. Now, anything more, Mr. Amit Singh, that you want to add apart from what has been argued by the others?
Your Lordship, may I also press a little bit? Just give me 2 minutes to address this issue. Because in a case, if Your Lordship's hold, I'm not for a minute suggesting that it has to be retrospective. I'm submitting that it has to be prospective. But what would be the relief? Relief would be pay and recover in case of a breach. If I establish a defense under section 150, Roman 2, I am not liable technically, but Your Lordship have in Swaran Singh said that in third party claims you pay and recover. I'm not for a minute suggesting that it has to be a blanket application of pay and recover. We are here, Your Lordships, dealing with transport vehicles. Transport vehicles necessarily implies that they are from multinational organizations, educational institutes who have the wherewithal. I'm not talking for a minute that innocent third parties or innocent owners or even a small time tour operators. For instance, like HCL, they have employees ferrying them around for a particular amount of fare. Those are transport vehicles. Why shouldn't HCL or any other company who commits a breach, who employs a driver who does not have the adequate license, why shouldn't they pay the first?
But can you not argue that in an individual case?
So, Lordship, that's why, because
Why does
forensic
that arise?
comes
But
into
forensic
play.
does not say that in every case that you have
No,
to
it says,
pay.
may I just point out?
It opens up a remedy of pay and recover.
Yes.
But Swaran Singh certainly can't be construed to mean that where your, the transport vehicle was owned by, say, some big multinational, that therefore also the insurance company must pay and recover it from them.
That is what generally
right,
happens,
my
Your
lord.
Lordship. Pay and recover, that's the standard order.
It is the individual case basis still, my lord.
May I just also? Lordship, may I just point out just 2 paragraphs of
I should be settled the Swaran Singh correctness of Swaran Singh over here, Frank.
Your Lordship, because it has been doubted twice. May I show those orders?
There are a number of
Twice.
things are doubted,
But
I don't know whether
I'll
we
tell
should
you
take
one
it
more
up.
thing. There are also, look, there may be valid reasons why our colleagues who have preceded us in this have decided not to decide that issue and just disposed of the whole issue and kept it open. Because ultimately the court, in such a case, you have to balance it. Suppose if you say pay and recover will not apply, or you say Swaran Singh had no basis in law, look at what happens to the ordinary victim of an accident.
Your Lordships, may I say one thing?
The proper way to do it is that
in an
the
appropriate
Swaran Singh
case.
case, when this question is formulated properly,
Then you
everybody will address on that question. Then the court will be able to look into it and then come to a conclusion. But when the question is something else, it won't be proper also for us.
At least my lord may also indicate in this that actually my lord not interpreting the motion of Swaran Singh. Otherwise, the insurance company will, my lord, again.
No, we are not going to go into it at all.
Because my lord, what they will say that, okay.
Look, what we'd like
is
you to
not
do
going
now
so-
is we'd like to hear you on merits on the Devangan.
Please.
We'd like you to tell us how Devangan is right.
Lordship, I have 2 more points.
Yes.
Just 2 more points. 5 minutes, not more than that. My second question, Your Lordship, is whether in the...
Devrat, how long would you take?
Not much, but I'll finish today.
And followed by? Devrat, about today, where you take 20 minutes?
I'll try
You will
to.
be able to complete it
Finish it.
today.
It is possible.
He's finished today. He says half an hour.
I think 1 hour is enough for all of us.
I'll take 5 minutes.
This site was heavily insured.
But we've already paid. Whatever dues were there, we've already paid with a direction that we will not recover. Last order says so.
Their clients are safe. There's no difficulty.
yes.
They're arguing it to assist the court.
Out of 70, only 3 or 4 have turned up.
Yes.
Pro bono.
They're all appearing. You must be all appearing pro bono, right? Your client should have.
Which is why I said, this is heavily insured.
So at least, my lord, also give a patience hearing, my lord.
No, we need to have that
We
perspective
also need,
I
we
will-
need
I
to have a
will-
contra perspective, because frankly, as you would have obviously understood,
Yeah.
we have been prima facie impressed with the submission on this side, but we are always open until the last word is said. So we'd like a contrary viewpoint.
Lordship, the other,
Yes,
just,
Tell us the.
yes,
on-
Lordship, only on the relief, because I don't want to repeat the arguments.
right.
The other argument, Your Lordship, is that when we are establishing breach under section 149(2), now section 150, Your Lordship, since Swaran Singh had said that the burden is on you, on the insurance company to establish a particular breach. That view, noticing Swaran Singh, Your Lordships have taken a different view in Pappu versus Vinod, which is at page 56 of my
Which is that
compilation.
the insured must establish that.
Yes, Your Lordship, the initial onus is on the insured. So I'm saying, Your Lordship, in cases like.
The insured is the victim of an accident caused by a person with whom he or she has no privity.
Insured.
Insured,
Yes.
right?
Insured, the owner of the.
The owner.
Owner of the vehicle will have to prove that he has taken all adequate steps before employing a driver. Because Your Lordship, pay and recover as an insurance company, I sought instructions, not even 5% pay and recover. Just in the books, they are written off as bad debts. Hardly any recovery.
How much do you have to pay per year? Tell us that. Is there do we have statistics of, for national insurance, how much have you paid, say, in the last financial year?
For pay and recover, Your Lordship, I don't know. I mean, individual cases, I'll have to seek instructions on that. But a lot. I'm saying that at least there appears to be, because Pappu. In Pappu versus Vinod, Your Lordships were Justice.
The issue of burden of proof, etc. also. See, one of the reasons why we don't want to expand it is that we must also have an adequate representation from the other side. They are appearing for a group of people whose clients have already been paid. Now to make them argue in response to something, which really speaking never arose in their case, they have no notice of that, and we decide that and lay down this wide principle. Should we not allow it to be decided by an appropriate bench, maybe an appropriate 3-judge bench? When you have live cases,
But they appear, Swaran Singh is also 3 judges. So is Pappu versus
The
Vinod.
time will come. Referred, so.
And my Lord Justice Chandrachud was a part of Pappu versus Vinod. Justice Mishra, Justice Khanvilkar, and Justice Chandrachud. This, because it's very difficult. Swaran Singh says that you have to establish negligence, you have to prove breach on the part of the
We understand
owner.
that that's troubling you very much.
Or as an insurance
And it doesn't arise here. You'll have to wait a little bit. Some other context we will take.
Some other matter.
I'm grateful, my Lord, for a patient here.
Yes, Mr. Devaraj.
I am concentrating my arguments only on the basis of section 221 and the element of weight, which my lord the side have argued is not important. My respectful submission, my lord. The weight constitute a very important elements of this act. There are too many definitions about weight. Section 2, subsection 3 defines axle weight. Thereafter, if your lordship may kindly come to subsection 15 is gross vehicle weight. Then it's 16 is heavy goods vehicle. The heavy light is all weight. 17 heavy passenger motor vehicles. Thereafter, lot 21 is light motor vehicle. Then lot may kindly have 23 is medium goods vehicle. These are all weight. The two very important facets on which the license are granted are LMV and HMV, which is light and heavy. So, in my respectful submission, the weight constitute a very important element of this act. Unlike what the other side have stated, in the light of what I have stated, I'll again read the section 21, which is light motor vehicle. Lordship has read so many times. Means a transport vehicle or omnibus, the gross vehicle weight of either of which, or a motor car or tractor or road roller, unladen weight of any of which does not exceed 7,500 kilograms.
12 feet of
I have circulated my written submissions, my lord. I think appear on the lordship, please. Thereafter, I'll just keep.
Yeah, you run through it.
Just run through the
Lordship.
Lords,
I have already read section 21, 221, my lord. And section 2 also, your lordship has seen, my lord. Looks 10-2, my lord, lordship has read. I don't want to take your lordship again. But my lord, subsection E, my lord, this was substituted in place of medium goods vehicle, medium passenger motor vehicles, para 4, my lord, I'm reading, heavy goods vehicle and heavy passenger motor vehicles. 1994, my lord.
It is clear. Just read
It is clear. The legislative intent is clearly to replace above said classification with a single class of transport vehicles. Thus, the expression transport vehicles will include only the heavy goods vehicle, as in sections 216, heavy passenger motor vehicles, as in section 2, clause 17, medium goods vehicle, as in section 2, clause 23, and medium passenger motor vehicles, as in section 2, clause 24. Well, however, the classification of LMV remained unchanged in
On the other hand, isn't there not intrinsic evidence to show that once the legislature brought in the expression transport vehicle, it would include transport vehicles of every description?
Well, I'll take you to a very interesting table. If you ought to make grant me liberty, it's the end of the submission.
Transport vehicles which are above 7,000.
Yes, I'm coming to that point, That table, is.
That's there in the Bayer Act also.
Well, yes, it is the end of my submission.
There is substance, there is something in it, because obviously then your contention is transport vehicle should include all transport vehicles other than those which fall into the definition of light transport vehicles, light motor vehicles.
Lordship, can we have this table, this is actually designed for the benefit of section 41, which is about the registration of the motor vehicles, Your Lordship, at the end of the submission, it is annexed. If there is a difference between transport vehicle and non-transport vehicle, that is being given by way of a table. That is the end. It is there in the screen. Lordship may kindly see, even if the point 3 is most interesting, motorcycle used for hire to carry one passenger on pillion and motorized cycle rickshaw for goods or passenger on hire. This is also transport vehicle.
Where motorcycle with
Three.
sidecar? Three.
Point 3.
Motorcycle used for hire to carry one passenger on pillion.
But the weight would be not more than 200 kgs.
Rapido.
This is also transport vehicle.
Rapido.
Not to please. And there are lakhs of them. Lakhs of them all over India. Everybody have to apply for a transport license.
That's the reason. That's the controversy going on.
Yes, sir.
They contend that it should not be, we should not be compelled to take license, and government says that unless a license regime exists, the safety can't be ensured. So therefore, we don't know who will be doubling up as a transporter today, and who will take him from his residence to the office, and what happens in accident if there is an accident. So therefore, a regime where somebody is utilizing his transport vehicle for transport purposes, licenses are necessary.
Lordship,
That is what.
there is a form 2 and form 4, which is
Absolutely no control.
which is similar respectful submission for such kinds of vehicles. There is a license which is separately provided for aggregators.
Yes.
Well, these are transport vehicles under the present scheme, Milord. They are run under the license of LMV. Lordship may kindly run through this table, Milord. Motorcycle with sidecar for carrying goods. That is also a transport vehicle. Motorcycle trailer to carry goods. That is also a transport vehicle. Third, I have read below. Motorcycle with a pillion rider. That is also a transport vehicle. Luxury cab, three-wheeled vehicle for transport of passenger goods, goods carriers, trucks or tankers or mail carriers, power tillers and tractors using public roads. Number 8, Milord, mobile clinic or X-ray van or library vans. Mobile workshops. 10 is mobile canteens. Private sector service vehicles, Milord, that has been defined, Milord. Public service vehicles such as maxi cab, motor cab, stage carriage, and contract carriage, including tourist vehicles, educational institutions.
Mr. Devrat, we'll give you a little time tomorrow. You can conclude. After Devrat, two of you are going to argue. Between the three of you, 1 hour, we'll conclude tomorrow.